My lord, under extremely compelling circumstances, I am mentioning a Group 1 new motion, Your Lordship. It's returnable tomorrow.
Yes.
The thing is that, Your Lordship, the respondent highway authorities are taking steps to demolish my property.
It's appearing tomorrow, you say?
It is returnable tomorrow, Your Lordship. I am praying for some precedence, Your Lordship, because then they'll come and demolish my property any day, Your Lordship.
You're mentioning upon notice?
I have given notice, Your Lordship, that it will be returnable tomorrow, Your Lordship.
দিদি উপরে দিকে রেখে দাও।
না কালকে লিস্টে থাকবে
উপরে দিকে।
Deeply obliged, Your Lordship.
May I permit it to mention two matters, my lord. One is it was an upgraded matter at that time. Service was not completed. So your lordship, please to fix the matter today. It is not appearing in the list.
Are you mentioning upon notice?
Yes, my lord.
Give the number. Give the number.
But on another matter, my lord, it was also upgraded matter, but on that day, state prays for time. So it was adjourned till today, but it is appearing under the heading motion, my lord. It will
Mention matter only for 1 day, sir. Not after that.
It's a very urgent matter where
All matters are urgent.
la-
Please wait. It will be called. Please wait for your turn.
Wait.
Yes,
I
sir.
have lots of permission to mention one matter, my lord. It is appearing in the list for a long time, my lord, for upgradation with notice to the others.
What is your urgency?
Urgency, my lord, we are going to install statue of Sidhu Kanu. But it is being delayed and delayed. It was earlier, a petition was filed. Your lordship directed the SDO to consider the case. SDO passed order in our favor, but it is delayed month
The
after.
group 1 matter.
Group 1 matter.
Give the number, please.
Yes.
My lord, may I permit it to mention, my lord, for upgradation, the matter is that the mining lease has been taken for 5 years due to COVID time. The lease extension, representation and consideration is
Upon notice?
upon notice.
I am permitted to mention one matter. Your lordship was pleased to make this matter returnable on 9th of January. On 9th of January, the matter was not listed. And so I am praying for inclusion on this
Upon
matter.
notice?
Yes, upon notice.
Upgradation with notice to other side.
What is your urgency?
One matter, my urgency is that, my lord, KMDA, after issuing the note, issuing the letter that particular land was not acquired. But they does not remove the signboard of this particular land.
Give the number.
I beg to mention urgent motion. Urgency is that, my lord, I am the lessee of a part of the land. I am the owner of the same land. But I got the lease, mining lease, and my lease was not extended. For the reason I filed a petition, and in the said petition, this honorable court directed for filing affidavit. No affidavit as yet filed. Suddenly on 8 January 24, the district magistrate issued a tender notice inviting application from the interested bidder and the opening date of e-auction on 27 January. Well, this
Are you
urgency,
mentioning upon notice?
lordship, I have given notice.
Give the number. Give the
Two
number.
matters, lordship.
Yes. You're mentioning upon notice? Are you mentioning upon notice?
Yes, yes.
Mentioning notice. Please serve notice and come.
Lordship, out of extreme urgency, mentioning this matter to be moved unlisted, Lordship. The issue is I have been put on a notice of eviction to be evicted by 31st of January.
Why is there so much of side talking going on? কথা বলতে পারেন কোন? Yes, yes.
I have been put on a notice of eviction by the port authority to be evicted by 31st of January. That is the urgency.
File and give the number. I'll
Lordship.
consider.
My lord, may I be permitted to mention, my lord, on
Lordship,
extension of
1 minute, Lordship. May it be listed on Monday on a precedence, Lordship.
You please file and give the number.
Lordship.
may I be permitted to mention, my lord, one extension of interim order, my lord. My lord, item number 38 and 39 of daily list, my lord. I'm paying for upgradation, my lord. Extension interim order is expiring on, my lord, January 30, 2024, my lord.
You still have some time. Are you mentioning upon notice?
My lord, I am
Please mention upon notice.
grateful.
Leave to file দিয়ে নি উনি ফাইল করে নাম্বারটা দেবেন আপনাকে Yes, call the days list, please. The revisional application has been dismissed. Section 465 of the Code of Criminal Criminal Procedure has been set out. I'll read out the operative portion. In the present case, evidence has been concluded and the trial is on the verge of completion. In view of cognizance being taken by the Court of Sessions and the matter being tried by the Court of Competent Jurisdiction, the entire trial cannot be vitiated on the ground of initial irregularities which have been subsequently regularized by taking cognizance by the Court of Sessions. The court is inclined to hold there is no illegality or irregularity in the orders impugned, and the revisional application being devoid of any merit is liable to be dismissed. Liberty is granted to the petitioners to raise this issue before the learned trial court at the time of argument. Last part of the change.
May I take back, the photocopies of the?
Yes, yes, you can. Yes, next.
Number 2. Lord, I appear for the alleged contempt.
Yes.
Lord, may I find my response to the show-cause notice? My lord's order in the writ petition was, my lord, if your lordship kindly sees page 2.
To initiate proposal and conclude it.
So to initiate a proposal for direct purchase of the plot in question from the petitioners and complete the entire exercise within 3 months from the date of communication of this order.
Yes.
In the alternative, the state respondents are directed to initiate proceedings for acquisition of the plot in question under the Act of 2013 and take the proceeding to its logical conclusion within the 3 months from the date of
The alleged
communication.
contender is present in court?
Well, in fact, my lord, the alleged contender, this land acquisition officer, my lord, the name which is mentioned in the contempt application is Vasudev Sarkar, my lord. He is no longer holding the post. He is Mr. Anup Kumar Mondol, who is the present incumbent to the post.
But he was supposed to comply. He is responsible.
My lord, he is responsible. He has come before your lordship. So, my lord, what I am seeking, my lord, that this name, his name may be impleted, my lord. Anup Kumar Mondol. He is the present incumbent. Now, if your lordship kindly sees, my lord, my page 4 of my response to the show cause notice, my lord.
Yes.
My lord, this was the resolution taken in compliance of a lordship's order of the District Land Purchase Committee. It was dated 10th of October 2023. If your lordship sees at the bottom, scheme 2, direct purchase of land from Gurucharan Hasda, Mohanpur Moja, Jamboni. My lord, he is the writ petitioner. So the amount was approved by the committee, which is around 13,96,000. A direct land purchase proposal will be sent to the Irrigation Waterways Department.
Has
Right.
it been
Immediately thereafter, it has been sent to the Irrigation Waterways Department. There are a series of communication starting from page 7. In fact, even the irrigation, the Jharkhand Jila Parishad at page 8, they have also forwarded it. Then at page 10, the Chief Engineer Southwest Irrigation Waterways Directorate, well, he has written to the Principal Secretary for the Direct Land Purchase Committee. That was as late as on 3rd of January 2024. Then, my lord, these are the other two communications.
Where is it pending exactly?
To the Irrigation Waterways Directorate, because the land has been given to the Irrigation Waterways Directorate, my lord. They have to pay the amount. If your lordship kindly sees pages 17 and 18. Lastly, The special land acquisition officer, my lord, 17 and 19 to be precise, has written to the executive engineer Kangshabadi Canals Division, Chargram, to take steps for purchase of the land. So there are two parts of your lordship's order, my lord. One is to initiate the proposal, and the second to conclude the proceeding. So he has whatever was to be done subject to correction by my lord. He has already initiated the proposal. The district land purchase committee has sent it to the irrigation waterways directorate. It is now, my lord, the irrigation waterways directorate, my lord, to conclude this proceeding by paying the amount to the writ petitioner.
How much more time do you require?
But if your lordship kindly passes an order upon this principal secretary of the irrigation waterways department.
He is not party to the writ petition or the contempt application. That's the difficulty.
Well, I'm not seeking your lordship's matter. Your lordship did not implement them as a contemner. At least pass an order, my lord, saying that it is the principal, the irrigation waterways department who should take immediate steps for complying with your lordship's order, because they have to pay that amount.
The executive engineer Kangshabati Canals.
But your lordship may directly pass it upon the principal secretary, my lord, which is appearing at page 10. But he is the highest authority.
Affidavit of show cause. The alleged contemptor is present before this court. Paragraph affidavit of show cause submitted by the alleged contemptor is taken on record. Paragraph learned counsel for the alleged contemptor submits that
তোকে পাশে ঘরে যেতে হবে, তুই চলে যা, সাংঘাতিক অর্ডার হয়ে যাবে, তুই চলে যা।
the former special land acquisition officer Vasudev Sarkar, who has been impleaded as the alleged contemner, has been transferred. And what is the name of the present
It is there, my lord, Mr. Anup Kumar Mondal.
and Sri Anup Kumar Mondal has taken charge of the special land acquisition officer Jhargram. Paragraph in view of the above, Sri Anup Kumar Mondal be impleaded as alleged contemptor number 2 in the contempt application. Paragraph, the cause title of the contempt application be amended accordingly. Paragraph, since learned counsel for the alleged contemptor is representing both the alleged contemners, comma, further service of notice is dispensed with. Paragraph, it appears from the affidavit of show cause that that in terms of in compliance with the order under contempt, comma, the 9th respondent of the writ petition has initiated proceedings for direct purchase of the plot in question. And has requested the principal secretary to the government of West Bengal, comma, irrigation and waterways department for complete government approval with placement of fund to the appropriate authority for direct purchase of the acquired land. Stop. Such fund is yet to be placed before the authority. Paragraph, it appears that the direction upon the first alleged contemner has been complied with by him. Paragraph, since the matter is awaiting approval and funds from the irrigation and waterways department, comma, the Principal Secretary to the Government of West Bengal, Irrigation Affairs Department is directed to take necessary steps for completion of the entire proceeding for direct purchase in terms of the order passed by this court on 6 April 2022 in WP 15370 within bracket W or /2017 within 1 month,
within 1 month, my lord.
within 1 month from the date of communication of this order.
আমি প্রশাসনের সঙ্গে কথা বলছি।
Paragraph, let the matter appear under the same heading on 27th February.
27.
A paragraph, personal appearance of alleged contender number 2 is dispensed.
I'm grateful.
Next.
I'll answer the petition.
Milord, the order has been complied with, Milord. The last person has been removed today morning, Milord. Kindly keep it on Monday, Milord. We'll file a compliance report, Milord. But I've got some photographs to show to your lordships.
Yes.
Fully not complied. Still one structure is there.
No, it has today morning. It has been removed.
As we have seen in the morning,
Yes.
today morning,
Let it appear on Monday
my lord.
on prayer of the Monday. On prayer of the alleged contender, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th January.
Obliged, my lord.
I'm grateful.
Court going to affidavit of compliance is submitted on the agenda. Affidavit of compliance on the next day.
Yes, yes. But may it be on 30th because
Morning,
by the
information has to be done.
30th.
30th. Join the 30th.
My lord.
Each. Yes.
My lord. Item 4. I am for the applicant, my lord. My lord, last occasion, lordship pleased to direct me to substantiate whether they have acquired 4 plots of land or not. My lord, in this regard, kindly come to page 26 of my writ petition, where one notification issued by the competent authority before
What was the
taking.
order under contempt?
My lord, order under contempt is we will make comprehensive representation to the competent authority, that is executive engineer irrigation, and they will make an inspection. Thereafter, they will give the compensation amount to the landowners. My lord, they held one inspection, and thereafter they have given 7 persons out of 9. My lord, rest 2 is, one is 4 plots of land. They are saying they have not acquired 4 plots of land, but my lord, according to me, they have acquired 4 plots of land. My lord, kindly come to page 26 of my writ petition for a moment, my lord. The exception. No, that is another matter. এটা অন্য ম্যাটারটা। না, এটাতে তোমার তো সব কাগজপত্র দেওয়ার কথা। না, কাগজ তো নিয়ে এসেছি, কাগজ দিয়ে দিচ্ছি আপনাকে।
Yes, page 26.
Page 26, my lord, ঘোষণা ফার্স্ট thereafter এই জমির একটি নকশা বিশেষ ভূমি অধিগ্রহণ আধিকারিকের কার্যালয় দক্ষিণ 24 পরগনা নবকোষাগার ভবন 5ম তল আলিপুর কলকাতা 27 এ দেখা যাইবে। মৌজা সীতারামপুর ক্ষেত্রাধিকার তালিকায় সোয়ানসো থানা পাথর প্রতিমা জেলা 24 পরগনা সম্পূর্ণ RS দাগসমূহ। My lord, thereafter second line 439 and 40. My lord, may I give my copy? I have marked it. 439 and 440.
Yes.
Thereafter, my lord, kindly come to
another column where 259 Poschim Mangsho,
This was part of your representation.
part of the representation.
So what have they said? What, that they have not?
They have
acquired
said
this
they
far?
have not acquired it. My lord, I have
My lord, last 19, my lord, I have,
The affidavit.
previously, my lord, I signed one
Yes,
report,
yes,
my lord.
yes.
Yes, my lord. Status report I filed, my lord. If your lordship
This is
will
an
see-
affidavit of compliance. You have filed an affidavit of compliance on the earlier date.
Legal complaints, no, status report to file.
এই যে
Well, your lordship was
এই যে
pleased to,
এটা তো
You have filed an affidavit of compliance.
my lord, if your lordship will see that I give it to a page 2. Page 1, my lord, what portion of the verification of the page 1, my lord,
এটা তো
that is verified of the office records and concerned author.
Yes.
All that.
এটা আগে
Last, my lord, page 2, my lord, on the previous occasion, my lord, your lordship was pleased to direct whether the land whose name the land was, my lord, award was passed, my lord. That is second paragraph, third paragraph, my lord, page 2. The petition number 6, Mahadev Das has failed to produce records
Yes.
for rights over plot number 440, so the claim of the company in favor of the incident petitioner over plot number 440 does not arise here. Awards details number. And my lord, writ petition number 8, Purnachandra Das purchased the plot number.
That's a
as by-
post-acquisition purchase.
Yes, my lord.
পোস্ট acquisition.
So
My
he
lord,
is not en-
for this, my lord, he must file all the documents.
My lord,
How? My lord, today, my lord, what he said, my lord.
my lord, I have
He can't go beyond.
I
the
brought
petition,
all
my
the
lord.
documents.
If it is a post-acquisition purchase, you have to show that the predecessors were not given compensation,
Yes, my lord.
the vendors.
My lord, my lord, it was purchased in the year 2005, but the completion of the deed
My lord,
was
I
2013.
request
My
you,
lord,
to give me all the details. My lord, I send them all the.
Why
things
don't
to
you file an exception with all the
my
details?
lord,
My
it
lord,
will
I-
take
I
only
request
Mr.
you, my lord,
it
on the
will
subject
take
of-
only 2 minutes time
Only two,
with
6
regard
and
to
8,
the
my lord, is there.
You are making oral submissions, sir. Come, file all
Your
the
lordship,
documents.
if your lordship
তুমি
allow me
document
to
দাও না, আমার সুবিধা
allow
হবে।
me to file the
Submit an
document.
exception, annex all the relevant documents in support of your case, so that Mr. They can take up the matter with the
Only
authority.
for 6 and 8.
Well,
Only for
6 and 8.
Other,
Only for 6
all-
and 8. Yes, yes.
my lord, I can
File
see
all the
and my lord
documents.
complete the
Yes,
proceeding.
yes,
my lord.
yes.
If lordship, can you direct
When
me?
can
I'll,
you come back with the exception?
my lord,
When can you come back
my
with the
lord,
exception?
another similar matter is fixed on 9th of February.
So let this also appear on 9th of February.
Yes, my lord.
Please serve an advance copy.
My lord.
Learned counsel for the applicant slash
Affidavit.
petitioner seems to use an exception to the report in the form of, to the affidavit of compliance submitted on behalf of the alleged contemner. Paragraph, let the matter appear under the same heading on 9th February.
9th February. Grateful, dear lords.
Next.
আপনি কার হয়ে আছেন? Lord, I beg to appear for the petitioner. Lord, this is an application for recalling of your lordship's order. But not, sorry, what is, Lord, the problem is that, Lord, we have sent the copy to the private respondent in the same address upon which we sent the writ petition. But now the writ petition was served, now it is showing insufficient address. The writ petition was sent to the same address. The application, when it is sent, now it is showing, Lord, insufficient address.
Why don't you try once more?
But
Find out
I will do that. My lord, I am asking for additional order from your lordship, Mr. Tulsidas Rai. He appeared for, Lord, the private respondent in the order in of which recalling we are asking for. Kindly also, my lord, allow me to serve on Mr. Rai.
private respondent as well as his learned counsel.
Yes, yes, both. We'll do that again and upon Mr. Rai also.
For the state.
Lord, I'm filing the affidavit of service.
Not
Oh,
so.
I'm filing a supplementary affidavit, Lord. Kindly take it on record. And affidavit of service, whatever is there on record, kindly take it, man, Lord, and
Not an
recording that.
affidavit of service at all.
No, no.
Come back with an affidavit of service.
Yes, we'll do that. We'll file another one. Take this on record and direct me to serve again because it is not complete.
Supplementary affidavit and affidavit of service filed on behalf of the applicants You are the petitioners in the,
Yes, writ
no,
petition or applicant. But I tell you lordship what happened earlier, a writ petition was withdrawn without liberty of your lordship's court. Now, my lord, your lordship, my lord, dismiss the writ petition, my lord, that on the point of public policy, order 23, rule 1, sub rule 3, that I cannot maintain. But perhaps it was not shown to your lordship, the writ petition which was withdrawn, prayers made therein, the prayers made herein are, my lord, different. And my lord, public policy, I'll try to address your lordship, my lord, public policy, my lord, has to be adjudged on both sides. Somebody is occupying a public land. He cannot come and say that a public policy will stop the petitioner from approaching the writ court.
wait, come back.
That's the only thing.
uh, whether writ petitioners / applicants are taken on record.
সকাল থেকে ওটা পড়ে পড়ে এসছি এখন
Paragraph, since service upon the private respondent is not complete, comma, the petitioners are directed to
সকালবেলা উঠে
serve the private respondent and learned counsel for the private respondent who appeared in the writ petition and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 19th February. Next.
Item 6, my lord, I beg to appear on behalf of the petitioner. My lord,
Lordship, for the respect number
Your
11.
Lordship, kindly recollect, my lord, this matter relates to an acquisition where Defense of India Act applied. Your Lordship, earlier occasion hold an opinion.
Not acquisition. It is public
Let me-
premises, eviction of unauthorized
let me-
documents. Well, here the
Let me
unauthorized occupying.
Sir, let me complete.
DM's order is there, appellate authorized order.
Going to the merit, my lord, I am appealing for the state, my lord. I received some instruction, but which is not, my lord, sufficient according to me. I need further instruction. So, my lord, I am praying, my lord, 7 days time at least, my lord, kindly.
My lord, I am appearing for respect number 11.
Last,
My
kindly
lord, I
see my
shall be
last
making
order.
a submission, my lord. Lordship may accept that, my lord, or consider that. Before, after conclusion of the submission of my learned friend.
There is an interim order in this.
Yes, my lord, and there is a earlier occasion, what happened, my lord? Your Lordship hold that the acquisition is not, the documents, state failed to produce any sufficient documents. Your Lordship hold that acquisition is not in consonance with law. Thereafter, state seeks the time to collect all, kindly see your Lordship order 6 December 2023. Your Lordship seeks time to file all documents regarding the acquisition. So now the state is taking time, so my lord, interim order is
Has
explaining.
to be extended for a limited period.
Yes, my
My
lord.
lord, I beg to join issue on the issue submission made by. It is not a case of acquisition challenged by my learned friend today. In 2010, my learned friend has accepted that this acquisition was made and he is only having two.
This matter cannot be taken up for hearing if the state wants to come back with a.
State's answer is not required at all. DM's order is covering the entire issue.
Judge that, sir. The state has to be given some opportunity. Please
State
come
was
back
given
with a-
opportunity. State is delaying the issue.
Learned counsel for the state respondents seeks further accommodation to, you'll come back with a report?
Not report, my
You have
lord.
to
but with
annex these
instruction, my lord.
documents.
With the instruction, my lord.
You have to
Report has
annex the
already been filed.
documents. You wanted to produce documents.
Document.
Documents, my lord.
So how will you produce documents without a report?
My lord, my lord,
It has to be on
my
affidavit.
lord, my lord. My lord,
To-
the form affidavit already has been submitted, my
A
lord.
further report
My lord.
annexing the relevant documents.
Document page acquisition.
Page,
To submit a further report in the form of affidavit annexing relevant documents. Paragraph-
2 weeks, my lord, 2 weeks.
Yes,
2 weeks.
paragraph, let the matter appear under the same heading on 16th February.
16 February.
Interim order, my lord.
Paragraph, the interim order granted earlier is extended till 29th February or until further orders, whichever is, comma, whichever is.
Instead of the 16 February, my lord, can be taken, my lord, next week, but thereafter, my lord,
20th,
20th, my lord, my lord.
yes,
February,
February,
my lord.
20th.
Interim order, my lord. Extended up.
29th,
As well. Appearance টা দিয়ে দে।
next,
এইসব কাচালি করে রেখেছিস কি হবে?
7th.
Wait, please, my lord. On the last occasion, my lord, had granted us leave to file exception to the report filed by the authorities, my lord. We are little delayed, my lord.
Have you served the copy?
My lord, in that case, my lord, let the matter be posted for hearing on a subsequent date as per my lord's convenience.
What is the matter about?
My lord, yes, my lord, the matter is, my lord, it is unauthorized construction and obstruction in front of my landed property,
PWD land.
PWD land, and the state is also in cohorts with the private respondents. They have culled out a Bata Dag number.
Oh, yes, I can recall. And they say that.
They say that your complaint is not relevant to this. Although there is admission that there is PWD land in front of my property and there is encroachment therein, but on technical grounds,
that part where the state admits.
It is the private respondents who have admitted before the district authorities, my lord, before the executive engineer. My lord, that's at page 85 of my lord's brief.
In that report, my lord, that is.
Has my lord got 85?
85, yes.
The second last paragraph, Shri Kalipodo Shamanto. Shri Kalipodo Shamanto and 6 other private respondents agree with the above noted statement as they are running their business over the government land, but they are maintained their livelihood by their business. So there is a clear-cut admission that the private respondents are running business on the government land in front of my private property, but the state is in cohorts with them, and they say the complaint is in regard to plot number 1817, whereas by operation of KB, I am now located at Bata Dag number 1817 by 2442. Therefore, this they need not look into these records at all.
That is your case also, that it was subsequently a Bata that renumbered as 1817.
No, I am not aware of it. But my grievance is very simple, my lord. There is
petition.
Yes, there is encroachment in front of my land, and this encroachment is on public property. Therefore, it has to be removed, irrespective of the fact that whether I am on the original plot or on the Bata plot. And they are throwing me out of the proceedings on the ground that my complaint is regarding the main plot number. And maybe by mistake or otherwise, I have not mentioned the Bata Dag number.
You have actually mentioned the Bata Dag number.
Yes.
Paragraph 2.
Yes.
Yes. Yes. So there is no dispute with regard to this. So what is
dispose of this matter directly the authority to
section to initiate section 10?
Yes. This is wonderful, my lord. I'm grateful to my lord, senior friend.
Yes, my lord.
This is Mr. Dev.
My lord. I take back all my allegations, my lord.
Reply, my lord. Exception.
No, not necessary. You will have your opportunity before the authority.
Yes.
Exception used by the petitioner to the report submitted on behalf of the state respondents is taken on record. Paragraph heard learned counsels for the parties. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have encroached upon PWD land adjoining his property, thereby obstructing his egress and ingress. Paragraph. It appears from an order passed by the executive engineer, Tomluk Highway Division, Public Works, within bracket roads, bracket closed, directorate. What order is this? Under which provision?
It is under. Well, there was direction upon the authority by this honorable court, and accordingly they had sought for a report, and on that technical plea they have ousted me. This order needs to be set aside.
This order is not impugned at all, not necessary. Let it remain as it is. on passed on 28th January 2020 that the private respondents have agreed to the fact that they are in occupation of government land and are running their business therein. Do you have a representation?
No, no, my lord, kindly comes to the impugned order, which is at page 99. Subsequent to this order, there were proceedings, and in page 99 is the order impugned, my lord.
Yes, yes, yes.
Otherwise, my lord, there is a contradiction of the
Yes.
order.
This page 99 has to be set aside, and after that, trial de novo, fresh.
Fresh procedure was started and after.
Yes, strangely, I'll just record this.
Yes.
Strangely, comma, in the order impugned, passed on 28th February 2023, comma, the executive engineer has recorded that it is noticed that the private respondents have not encroached upon any government land in front of plot number 1817.
Well, though it was admitted in the body of the order that we are encroaching the.
Yes, that's in the earlier order.
Yes,
And
but
this
here-
order, they say this. That's why I'm recording this.
Yes.
Comma, which is contrary to the admission of the private respondents as recorded in the earlier order. Stop. Paragraph in view of the above, the order impugned dated 28th February 2023 is set aside. Paragraph, the third respondent,
Respondent number 3.
he'll do it. The executive engineer, comma, Somlok Highway Division, comma, Public Works Department within bracket roads, comma, Government of West Bengal, comma, being the second respondent here in comma, is directed to take necessary steps for demarcation of the plot in dispute in order to ascertain the quantum of land encroached upon by the private respondents. Stop. In the event upon receipt in the event upon receipt of such report, comma, the second respondent is directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 within bracket, since encroachment has been admitted by the private respondents, bracket closed, and take the proceeding to its logical conclusion within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
Not one indulgence, my lord, the BLRO should also cooperate. That one line should be incorporated. BLRO is respondent number 5, my lord. Because he is the main troublemaker.
Paragraph the Block Land and Land Reforms Officer, comma, Potashpur hyphen Roman 1, comma, being the fifth respondent herein, is directed to cooperate with the second respondent in compliance.
He will comply, he will file the report within 1 month.
Yes.
That is ballot, it has.
And submit the demarcation report before the second respondent within 1 month from date upon holding the demarcation as indicated in this order in presence of the petitioner and others concerned. Stop.
ঠিক আছে ডিপ লুক
Chatline have disposed of chatline. একটা কাজ জিনিস করবেন তো demarcation পার্টটা আগে দিন, তারপর upon receipt of demarcation report করে তারপর ওটা পরে। এখানে take necessary steps for holding demarcation, তারপরে ওটা ঢোকান। ওটা এটার পরে ঢোকান। Take necessary steps for demarcation এখানে বললাম তার আগে। The second respondent is directed to take necessary steps for demarcation. তার আগে। Second respondent is directed to তার আগে। এইখানে ঢোকান the BLLR যেটা বললাম, হ্যাঁ fifth respondent ঢোকান, তারপরে upon receipt of demarcation report বলেছিল, হ্যাঁ তাই আছে? হ্যাঁ হ্যাঁ হ্যাঁ। Yes, next.
Ultimate.
So I appear for the respondent number 2 in 8 as well as in 9.
Yes, Mr. Shamanta,
I am
both
for
the matters?
both the matters I am for the petitioner.
কি রিপোর্ট সাবমিট করে দিন। এটা বোধহয় পরের ম্যাটারটা না, একটু অন্য মামলা, কি নাম রামকুম দে।
Report of the state respondents?
I have also
You have filed a report.
I have filed the state also has filed because the exception has been served upon me. Serial number 8.
No, only one report is on record.
In one matter, exception.
See, by the respondent number 2 is on record.
Yes, yes.
That is my.
Yes, you are two. Yes, your report is on record. State, has the state filed a report? You have received copy?
I have received the exception used by Mr. Samanta's client.
Against your
The
state's report?
state's report.
I do not find any state's report in file. Mr. Shamanta? Have you received a separate exception to your report?
No.
So this should be to your report.
No, Lordship, the thing is, in my report, the person, the deponent who has affirmed the affidavit, in the exception, Mr. Samanta's client has mentioned another name. That must be the deponent of state's report.
But there is no report.
Because
filed by
my
the state.
report was affirmed by Shobhi Panigrahi, and the exception which I have received, name has been mentioned Somnath Haldar, Special Revenue Officer.
Is that in the
He cannot
next?
be my client.
Is that in the next matter?
No, the 899, that is serial number 8.
Is it in 9 by any chance? No.
Number is mentioned as serial number 8.
8. Mr. Shamanta?
In any way, Lordship, Mr.
Yes, we can deal with the matter. Yes, Mr. Shamanta, please place your case. Yes, Mr. Shamta.
My lord, your lordship, in first matter, my lord, your lordship was pleased to dispose of the writ petition on 26th of September 2022. And your lordship directed by the petitioner, directed the respondent of 4 to concern dispose the presentation of the petitioner dated 8th of April 2022 within period particular date matter within period 6 weeks and date of communication of the
Where
order.
is it at page?
And that is at page 55, it starts the lordship order.
Yes. Yes.
Now therefore, my lord, the ADM, the appellate authority matter passed the order on 1st of November 2022.
Page 56.
Page 57.
That is the order impugned.
In the first matter. That is the order impugned.
Yes.
ওই ADM এর অর্ডারটা 56 এটা অর্ডার হলো অর্ডারের পরে হিয়ারিং দিয়ে এই হচ্ছে order।
Well, in effect, my lord,
আমরা দিনের পর দিন ফেলে রেখেছি তো
Why was the earlier auction cancelled?
ঠিক আছে
my lord, earlier auction was not cancelled. My lord, your lordship kindly come to page 59. My lord, cancelled by this process after your lordship's order was passed, my lord. That was cancelled. My lord, your lordship can they banked upon the clause 10.7.1. Man, if your lordship kindly come, that clause, page 38. In both the matters, that is the principal question of challenge matter.
Page 38, yes.
Page 38, my lord, page 38.
এখানটা
My lord, in upper portion, my lord,
কি ব্যাপার
page 38 of
10.7.1 is page 37, yes.
37, my lord. 10.7.1.
Yes.
Notwithstanding anything contained in this bid document, the state government district committee reserves the right to reject any bid and or to annul the bidding process and reject all bids at any time without any liability or any obligation for such acceptance, rejection or annulment and without assigning any reasons thereof. This is under challenge, my lord. Whether the state authority can impose such condition in tender process, my lord.
Have you challenged this in the writ petition?
This is
it has been challenged, but after 5 years of the tender was invited and after his participation in the tender.
yes, maybe that may.
This
but-
tender was
but-
invited, cancellation was made in
Because I was-
2018
because I
and 2023. This particular clause has been challenged after the petitioner participate himself in that particular tender process.
my lord, kindly
Whether
please-
this delay can be condoned after 5 years is hopelessly barred by the law of limitation. Because at the time of participation of the tender, the petitioner was well aware about that particular clause. In spite of she participated in the tender, she took a chance, and ultimately when the tender was cancelled due to any administrative reason, After 5 years of that cancellation order, in 2023, this was challenged. Whether that is permissible.
Yes, Mr. Shamanta, how do you respond to that?
Well, yes, no. No?
Mr. Shamantu, you don't seem to be ready today.
I
You want
believe
to
we
come back on another
possibly
day?
is.
Do you want to come back on another date? You don't appear to be ready today. And are you using an exception to the report? There is no exception filed by you.
No, I have filed.
না আমার যে রিপোর্টটা ফাইল করেছি
আমি
তার
ফাইল
exception
আমি
দিয়েছেন
একটা
কি?
পেয়েছি, একটা দিয়েছি। আমি একটাতে পেয়েছি, একটা দিয়েছি।
এই যে দেখুন আমি যেটা দিয়েছি আপনার রিসিপ্ট
এই যে
Yes, it is.
এটা দিয়েছি, এটা পেয়েছি।
সোমনাথ হালদারটা আমার না, এটা স্টেটে, এটা স্যার সমীপখানি দেওয়া আছে, ঠিক আছে, হ্যাঁ আবার দিয়েছেন, আমারটাও দিয়েছেন, অন্য ব্রিফে ঢুকে গেছে বোধ হয়।
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading. Matters are adjourned. Duto matter. Let the matters appear under the same heading on 21st February.
বইটা বলুন।
Next.
My lord, I am appearing for the petitioner. My lord, Mr. Shovoto Mitra is appearing on behalf of the petitioner. My lord, in this matter, the state respondents were directed to file a report and we were directed to submit a exception to the report.
Where is your exception?
No, my lord, the state respondent has not yet filed a report and served it on us.
Who is appearing for the state respondent? Mr. Ganguly was appearing, Mr. Oshim Ganguly. Where is he? None appears for the state respondents. Paragraph, let the matter appear under the same heading on 22nd February. Paragraph, it is made clear that the matter shall be taken up for hearing, the matter may be taken up for consideration on the adjourned date, even in absence of the state respondents.
Grateful, my lord.
Next.
Yes, my lord. I am for the petition.
I am for the state.
My lord, this is the second round of litigation before your lordship. The first round of litigation was also hard and disposed of by your lordship. And to cut short of the matter, if
Are
your
you
lordship,
filing an exception today?
no, sir, lordship, presently I don't think that no exception is necessary. My lord, if your lordship kindly to cut short of the matter, kindly take straightway page 62 of the writ petition and accept P14. It is your lordship's own order. Here the facts will be clear, so I may not repeat the facts. May I place it? Affidavit of service filed in court today is taken on record. The predecessor in interest of the petitioners, Madan Gopal Mullik, since deceased, was allotted a plot of land measuring about 8 kathas in the year 1963 by the second respondent by virtue of an agreement executed on such and such. The original lessee expired before the deed of lease could be executed, and the petitioners, being his legal heirs, stepped into his shoes. In the meantime, the wife of the original allottee and one of his sons also expired. The petitioner submitted several representations before the authority requesting death mutation of the leasehold interest in their favor, but to no effect. The petitioners pay for direction upon the authority to consider and dispose of the representations submitted by them after giving them a reasonable opportunity of being heard. Upon considering submissions made by the learned counsels appearing on behalf of the parties and materials on record, the writ petition is disposed of, directing the second respondent to consider and dispose of the last representations submitted by the petitioners on 13/9/21 within 2 months from the date of communication of this order, after affording reasonable opportunity of hearing to all the interested parties, including the petitioners, in accordance with law. So it was clear that after within 2 months from the date of communication, the respondent authority shall take a decision. My lord, if you'll also kindly take the next page, page 64.
That's the communication.
Communication. Thereafter, they sent a notice of hearing, and they fixed a notice hearing on Lordship will find at page 65.
Yes.
They fixed a hearing on a certain date in the year 2022 by a letter dated 18th of August 2022. It was communicated. My lord, hearing was taken, but nothing was happened. 2 months have elapsed. Thereafter, a reminder have been given. Lordship will find at page 66 on 27th of January 2023 for alleging that the order of the Honorable High Court has been violated with for non-compliances of the order passed by this Honorable Court. But thereafter, a contempt was filed. Contempt is pending. During the pendency of the contempt application, they issued the impugned order, which is under challenge in this petition. Lordship will find at page 68. My lord, I'm placing my lord.
It was passed upon hearing the petitioners.
Lordship? Yes. Upon hearing the petitioners. My lord, in compliance with the order of the Honorable High Court dated such and such, this matter was taken up hearing by issuing notice. This was passed on 30th of January 2023. Hearing was taken in the August 2022. This matter was taken up hearing by issuing notice to all concerned. Petitioners were duly heard and petition dated 13/9/2021, that was the last representation, was duly considered with reference to that effect of office records and the documents produced by the petitioners at the time of hearing. It is evident from the records it is in respect of the plot number such and such at Kollani, and this plot of land was originally allotted to Sri Madan Gopal Mullik on 9/11/1963 as per the lease agreement, and the physical possession of the plot measured an area of 8 katas nil chatak 16 square feet was handed over to him on 19th May 1968, and it was revealed that the office record that the salami of the plot was not paid in full, along with the interest by the original owner in terms of clause 4 of the lease agreement. It reveals that the original allotee failed to construct residential building, violating clause 9C of the lease agreement. And it is also observed that the allotee failed to complete the registration of the lease deed as per the lease terms of the clause 10 of the lease agreement dated such and such. So therefore, my humble submission, by in this impugned order, they have alleged that there were violations by the original allotee in respect of clause 4, clause 9C, and clause 10. My lord, if your lordship kindly take trouble to come the agreement.
Page 38 is 9C.
Lordship, I'm grateful. But prior to that, page clause 4 is necessary because they have alleged that there was due in respect of payment of salami. Clause 4 of page, Lordship will find at page 35.
Yes.
Should on actual measurement after demarcation of the boundaries of the plot at the site, the area of the said plot be found to be more or less than the area mentioned above, then the premium or salami payable at the rate aforesaid shall accordingly be increased or decreased, and in case it is increased, I shall pay the additional amount within a fortnight from the date of the demand. This is the most important. There must be a demand made by you on your behalf or by the government for payment of the said additional sum, and in case it is decreased, I shall be entitled a proportion rate refund and shall get the government the amount by which the said amount of salami be decreased or abated within 45 days from the date of measurement. Now, my lord, if your lordship kindly consider in this regard what I have submitted, my lord. But from the lease agreement, it appears
Did you receive the show cause notices?
never. No demand. But if you lordship kindly take My lord, my humble submission, there was no due. My lord, if you will also kindly take page 33.
Yes.
My lord, paragraph 1. This is the part of the agreement. We agree to pay premium or salami at the rate of rupees 610 per katha of the said plot of land, which contains an area of approximately nil bighas, 8 kathas, nil chitak square feet. And the annual rent rupees 1. Out of the said premium or salami in respect of the said plot, we are depositing rupees 488, being the 10% of the amount of the said premium or salami. The first point is this: 10% of the entire premium, that is rupees 610 into 8. If we calculate this, then it will come 4880, 610 into 8, and 10% have already been paid, 488. And thereafter, after making the entire balance payment, the question of possession shall come. Now, here, during the lifetime of Madan Gopal Mullik, that is the original LOT, he never received any demand. After completion, my specific case is this: after completion of the entire payment, I got the allotment, I got the possession at the site since deceased. Now, in the report as submitted by the state, they have not given any calculation sheet whether originally there was any due or not. So my humble submission, only without any iota of any document, this type of submissions in a pleading is nothing but it can't be considered, my lord. Now, my lord, their second allegations that clause 9C. My lord, clause 9C provides, lordship already observed, page 38.
Yes.
To construct the building according to the rules as may be prescribed and according to the plans, elevation, designs, and sections as may be sanctioned by the government or any local authority or statutory in that way. Lordship knows that this department, urban development, this is a land authority. They are not they are not given any power to sanction any building plan. Only the municipal authority or any other statutory body can sanction the building plan. If the deed of the lease, as demanded by the original lessee since deceased and thereafter by the predecessor, thereafter by the heirs and legal representatives of the petitioners since of the original LOT, they repeated times sent their documents, prayed for mutating their names, and only after the question of execution of the lease deed and question of getting the plan sanctioned only can be available. Only heirs and legal representative can be, the names have been mutated, because this plot, originally the plot was allotted for 999 years.
The clause 9C says within 5 years from the date of lease. Lease has never been executed.
And it is, even if they have not produced any such document, as per clause 10, that on being called upon by the government, I shall within a week have the lease deed executed, registrations upon payment of the appropriate stamp duty payable thereof. So it is an admitted position. Neither the original LOT, since this is not the heirs and legal representatives, they never called for, the authorities never called for to execute the lease deed within 7 days. And if the lease deed is not executed, the question of construction of a residential building within 5 years, how can it be possible? Well, this is the simple issue in this petition. And the Lord.
Page 68, kindly see, my lord. Page 68, third paragraph, my lord. There is in order, my lord.
Yes.
But since the said LOT, my lord, got it, my lord.
since the said allotee violated the terms and condition of the agreement with him, several show-cause notice, wide memo number such as date 1973. Malad show-cause was issued in the
Please show me
1973.
the documents. Where are the show-cause notices?
But one documents I have annexed in my report, my lord.
All the show-cause notices I have annexed in my petition.
My lord, page 10
Only
of my report.
1973 show notice I have not, because that was issued in favor of the to the original allotee. Thereafter, since 2007, 2017, all show-causes notices I have been annexed. I have replied. We replied all the show-cause notices. Lordship will find.
73 is notice is not annexed, my lord, in this, my
No,
lord.
73. I
73 and
submit.
2007. My lord, two notices were issued. My lord, for completing the terms and conditions of the lease agreement.
Lordship will kindly
Then
check
after
page
turned up.
42.
But only on 2021 they have applied for death migration, mother. Prior to that, they may have turned up, they never approached for the authority for registration, nor they have submitted the draft copy of the registration for.
The initiation was supposed to be taken by the authority.
But we have issued notice in the 1973.
Notice, come to the agreement. Please come to your report. The clauses that you are referring to,
It's within 5 years, mother, 9C.
5 years off.
A date of execution of the lease agreement, mother.
So, and it is on demand of the authority.
But in the 68, mother, we have handed over the possession.
Clause 10.
Yes, sir, that I have seen.
On being called upon by the government. Where is this call?
Well, at 68, we have handed over the possession, my lord. There 1968, as it appears from lord.
Is it relevant?
But afterward handing over.
Handing over possession is not relevant because unless there is a deed of lease in the name of the lessee, no sanction plan can be obtained.
Yes, sir, without my lord, deed, no sanction.
Unless the land is in the name of the lessee,
Yes.
can the lessee apply for sanction plan?
But they could have approached my lord prior to the in that 2021 they are coming.
Please come to clause 10.
Yes, sir, I have seen.
On being called upon. So where is that call? From the government side, can you file any document?
It is appearing from page 68, only 73 one notice has been issued. Prior to that, that
68 is immaterial. That has to be set aside, sir. Please show me that the government has complied with the terms of the lease from their side. Then only the petitioner has the right to comply, isn't it?
From 63,
all the calls are from the government, should be from the government. Even it's on demand. Where is that clause? 9C, I think.
9C construction, my lord. 9C.
Clause 4.
Clause 4.
Clause 4 on,
say that additional amount was not paid.
on that clause, the lease has not been rejected. Can you see, my lord, the only my lord for not my lord complying the 9C and 10.
Yes, if it is even if it is 9C and 10,
yes.
Please see 9C and 10. What is that? 10 is your call. You have not done that. Due to non-compliance from the side of the lessor, the lessee cannot suffer.
And another thing, unless the deed is executed, how death mutation can be done, my lord? But they are not the my lord, unless the deed is executed, my lord, deed. The question of mutation does not arise.
Whose fault is it? Please tell me. The deed was to be executed at the instance of the lessor. You have not taken any steps. Clause 10, it is your violation. The petitioners have not violated.
Then let me take some instruction on whether it is even a demand has been made after execution of the lease agreement.
Yes, because unless there is a demand, the petitioner has no liability.
Yes, that is clear from clause 10.
And 9C says from the date of lease. So that is not applicable. That cannot be a ground for, that's not a violation at all. Since there is no lease, this clause is not applicable.
They are also sitting tight over there. They could have approached for the authority. Since 63, 2021.
When the agreement says the authority should approach, Does the petitioner have any liability to approach?
Yes, as I take some instruction.
Heard learned counsels for the parties. Paragraph by the order impugned dated 30th January 2023. The a request made by the petitioners for mutation of the plot in question in their favor was turned down on twofold grounds. Colon dash. The petitioners failed to comply with clause 9 within brackets C of the lease agreement and neither registered any deed of lease nor made any construction over the plot. Paragraph. Clause 9C within brackets C of the agreement indicates that the lessee should construct the building according to the rules as may be prescribed within 5 years from the date of lease. Stop. Since the deed of lease, no, get it in. Clause 10 indicates that on being called upon by the government, the lessee shall within a week have the lease deed executed and registered upon payment of appropriate stamp duty. Stop. Paragraph in the present case, comma, the state respondents are unable to substantiate that clause 10 was complied with by the government by calling upon the lessee to execute and register the deed of lease. Stop. Also, comma, since deed of lease was not executed, comma, clause 9 within brackets C is not applicable to the lessee in this case. Paragraph. Learned counsel for the respondents seeks to take further instructions in this matter, in this regard. Paragraph, let the matter appear under the same heading on February 13th.
Yes.
13th February.
Lots. Obliged to it.
Next. Next.
Item 12.
Actually, in item number 12, I'm led by my seniors, Mrs. SUVRA GHOSH. I'm praying for not this week because the supplementary affidavit has not been affirmed till now.
On prayer of the petitioner, the matter is
My appearance be recorded.
yes.
I'm for the petitioner. I'm my
Respondents,
exception.
who is appearing for the ECL?
Earlier 2-3 occasions my appeared. Noodle are him. No direction.
This is your exception to the report.
Yes.
On the earlier occasion also no one appeared. It will be heard even in absence of the respondents on the next date. Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph none appears for the respondents. Paragraph let the matter appear under the same heading on 23rd February. Paragraph it is made clear that
in the month of January or first week of February.
please inform them in the meantime.
Yes, ma'am.
It is made clear that the matter may be taken up for consideration on the adjourned date even in absence of the respondents. Please inform the respondents.
Well,
I am for the petitioner. Well, the last occasion, your lordship granted me liberty to file exception, and my client was ill and he was out of station for treatment. My lord, he has returned yesterday, and I can affirm the exception only on today. My lord, can you take it over tomorrow, my lord? I'm taking only not today, my lord.
Not today.
Today.
My lord, item number 15, I am appearing for the petitioner, my lord.
Yes.
My lord, on earlier occasion on 6 December 2023, my lord directed the state respondent to file a report, my lord. On the basis আছে একজন
এই রিপোর্ট নেবে পাঠিয়ে দাও
আমি পাঠিয়ে দিচ্ছি my lord may I get some time to file my exception, my lord?
Yes, please do that.
My lord, deeply obliged.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph learned counsel for the petitioner seeks to use an exception to the report. Paragraph let the matter appear under the same heading on 22nd February.
Deeply obliged, ma'am.
Next.
My lord, I beg to appear of the petitioner. My lord, on 8 December, my lord, your lordship was pleased to direct the state to, my lord, submit the report. দেবে নাকি?
হ্যাঁ দিচ্ছি কোনে দাঁড়া My lord, in this matter, my lord, I handed over the report to my learned friend, my lord.
Not handed over. Handing over.
My lord, the person is coming, my lord, he is in the ABDB affirmation department, my lord. So, my lord, I must file the report.
Today you're not ready with the report.
The report is, my lord, he is in the, my lord, for that
So
is
let there be some time. Please go through the report if you want to come back with an exception.
exception. He must.
Well, there is liberty is also given by your lordship or last order, my lord, for filing the exception, and I will file. My lord, only in general, my lord, the order was passed on 8 December, my lord. So, my lord, my interim order is required. Otherwise, any time on any date they can.
Interim order.
My lord,
That is also an interim order.
Status, well, only status quo, my lord, because if they, my lord, invite any auction, huh?
একদিন ধরে কিছু হলো না কালকে হয়ে যাবে তুমি না
বলে তখন আমরা কি করবো
পরের দিন হিয়ারিং এ হয়ে যাবে ভালো করে পড়ে নিও
First respondent 6 extension of time to submit the report in the form of affidavit as sought. Paragraph learned counsel for the petitioners seek to use an exception to the report. Paragraph let the matter appear under the same heading on 16th February.
16th February.
Next.
I am for the petitioner in item number 17, my lord.
Oh, my lord, 16th February, I have some personal difficulties, my lord. 18, 19, 20, my lord.
20th.
20th.
My lord, I beg to appear for the state, my lord.
Yes.
17, my lord, I am for the petitioner.
Yes.
My lord, precisely, my lord, this is an application for interest on the compensation. My lord, for more than 2 years, it was held up. My lord, the case is that, my lord, my land was acquired. Compensation was awarded. Since it was not being disbursed, so I preferred a writ petition before this honorable court. That was allowed. That is at page number 22. That order.
You are appealing for the state.
State.
What about the others, national highways?
Everybody has been served. State is the answering respondent. Respondent number 8.
Maybe, but you have implemented the national highways also.
Yes, yes, yes. I have served. I have served.
Your Lordship, Ms. Amrita Pandey and Aparna Banerjee are appearing for union, Your Lordship. She's at legs before another court, Your Lordship. I'm praying for not today.
Not
My
an
instruction
issue,
is
my
that, my
lord.
lord,
But
immediately
union-
after the order of the honorable court, my lord, the compensation has been paid.
Interest, he's on interest. not compensation. The interest part. You have received
lord-
compensation.
Yes, I have received. I have received. My lord, your lordship would kindly come to page number 22 once. My lord, this is the order.
Asking for interest on delayed compensation.
Exactly. At the rate of 10% as per the
Lord,
order of Justice Orijit Banerjee. That is all. That order is at page number 26.
26.
26. It has been upheld by the division bench and it has been upheld by the Honorable Supreme Court. 26 is the order of Honorable Justice Orijit Banerjee. 28 is the appeal court order, division
The
bench
same
order.
matter? In the
No.
same matter, the
In-
same petitioner?
No, not the same petitioner, but of the same plot of land. Another co-share. 26, 28, 34.
Yes. Similarly circumstanced.
My lord, I find from the writ petition that honorable Supreme Court also affirmed the order.
Yes.
And
So
if
why
that
did
be
you
so, my lord, I should not say anything.
no other option? How much time do you want?
My lord, 8 weeks. 8 weeks.
8 weeks to pay the interest. I'll record your undertaking that 8 weeks.
No, my lord, kindly fix a date, my lord. By 8 weeks, my lord, the calculation will be
Kindly
made.
make it returnable. Kindly make it returnable. Otherwise, going by the conduct.
I'll do that. I'll do that. Yes. I'll record learned counsel's submission. I'll make it returnable. The petitioner prays for interest on delayed payment of compensation at the rate of 10% per annum on the compensation amount of rupees 19,77,361 for the period 18th February 2019 to 28th June 2021. Stop. Learned counsel for the petitioner, paragraph. Submits that a similar issue was decided by a coordinate bench of this court by an order passed on 16th December 2020 in WPA 8628 of 2020, directing the Special Land Acquisition Officer WPA 8628 बोला order 5th February 2021. An order passed on 5th February 2021 directing the Special Land Acquisition Officer to pay interest on the compensation amount at the rate of 10% per annum for the period of delay. So admittedly, the said order has been affirmed by the Honorable Division Bench as well as the Honorable Supreme Court. Paragraph. In view of the same, Learned Counsel for the state respondents seeks accommodation to, you want to submit a calculation?
No, I have not submitted any calculation. Calculation has to be made. The Honorable Justice Arijit Banerjee has said delay will start from 1st March 2019.
In that matter.
But the same acquisition proceeding, my lord. Because kindly see page 19. This is the notice.
In terms of that order.
Yes.
In terms of that order.
The
In terms
period.
of that order, calculation be made by them.
Seeks accommodation to submit an assessment of such interest in terms of the order passed by the coordinate bench on 5th February 2021. Paragraph. Let it be in terms of the earlier order. The paragraph, let the matter appear under the same heading on 28th February.
I shall take instruction from my senior. My senior friend is saying to dispose of this matter, directing the authority to make calculation and pay the same within a stipulated period.
Going by the past conduct, then I have to file a contempt application.
No, why he is anticipating this, always state.
Kindly see the earlier conduct.
Let them come back. 28th February.
Well, I'm for the petitioner, my lord.
I'm for the state.
My lord, initially, the main crux of the point involved in this writ petition is this, my lord. Initially, the land was vested to the state. Thereafter, my lord, the division bench of this Honorable High Court, my lord, set aside the order of vesting. My lord, the state prepared an appeal before the Honorable Supreme Court. Now, the Supreme Court, my lord, passed an order of status quo. Now, my lord, in the meantime, my lord, thereafter, my lord, the BL and LRO, my lord, corrected the record of right in my name, my lord. My lord, thereafter, my lord, again the land was vested to the state without making any proceeding. However, my lord, in the meantime, my lord, the Indian Oil, my lord, Gas Authority, my lord, Barauni, my lord, land was taken, my lord, for the for the pipeline, my lord. My lord, my prayer is this, my lord. I make a representation before the authority, my lord, that may be considered, my lord. Or the petition may be, my lord, considered by the authority as a representation, my lord.
Where is your representation?
My lord, representation I have not been given, my lord. I will file before the authority.
You file a comprehensive representation before the authority,
My lord.
stating the order of the Supreme Court also.
My lord, my lord, my lord. That may be considered.
Mr. Pantwade?
At the last occasion, your lordship heard the matter at length, and your lordship was pleased to direct me to take instruction, but I have not received as yet. My lord, you may
There is a
let
direction
it
of
be
the Supreme
considered.
Court to maintain status
My
quo.
lord, as it appears, my lord.
Despite that, the authority could not have handed over. Will you do that? Will you file a representation?
I will file the representation and the authority will consider it, my lord, in terms of the order of this Honorable High Court, my lord.
It is submitted on behalf of the petitioner that the plot in question was originally recorded as a vested plot.
Thereafter, it has been again
originally
divested, my
indicated was recorded as a
Digest
vested
not
plot.
recorded right already been, I have been annexed, my lord.
কোথায় বলা আছে?
এই তো আছে না। এই তো page 60
আরে ওটা বললে হবে না।
2003 17/3/2003 দেখো রেকর্ড রাইটটা
ইয়েলো তো ভুল পয়সা খেয়ে করে দিয়েছে। ইয়েলো 2 নম্বরই আছে।
সে আমি বলবো কি করে।
ওখানে তোমরা অনির্বাণ
The
চক্র
vesting was set aside
করে
in this
দিয়েছো।
court.
This honorable court, my lord, by Justice, my lord, Satyabrat Sinha, my lord, sitting in a division bench, set aside the order.
Who is that order?
Yes, yes. My lord, page 34, my lord. Page 34.
34 is the SLP.
Sorry, my lord. My lord, last one.
তুই কি খুঁজছো বলো?
My lord,
খুঁজছো বলো?
ওই হাইকোর্টের অর্ডারটা।
হাইকোর্ট অর্ডার দেখতে পাচ্ছি না, আমিও পাচ্ছি না।
Oh, my lord, that I have been annexed, my lord.
Not annexed.
Has not been annexed.
Annexed, but the Supreme Court order I have been annexed.
The said vesting was set aside by a coordinate bench of this court, which was affirmed by an honorable division bench. So,
Well, it is stated in the writ petition, my lord, that writ petition was dismissed. That was, my lord, challenged the division bench.
It was, my
Division
lord-
bench, and then thereafter, my lord, the Supreme Court passed an order status quo.
My lord, initially it is filed before the single bench dismissed, went to the division bench, division bench, my lord, set aside the order of vesting. Against that, my lord, state paper.
Paragraph 4.
so you lost in the first at the first.
Lost.
First instance, thereafter in division bench, appellate court, my lord, I succeed, my lord.
Against
The
that
coordinate
state.
bench.
No, that is state.
The
Staying pending.
you filed the writ petitions.
I
You
filed
annexed them.
Not.
Vesting of the document. The petitioner challenged the said vesting order before a coordinate bench of this court in a writ petition being the number of the writ petition.
What is?
My lord, in FMAT number,
আরে FMT
18
নয়, WP number.
The
যেটা CO number ছিল। CO number. Not mentioned.
not mentioned.
Not mentioned.
FMAT টা আছে, CO টা কোথায়? CO
CO নাম্বারটা তখন CO ছিল।
লাস্ট FMAT টা আমার কাছে আছে।
FMT অর্ডার নেই।
আচ্ছা, বলছি।
CO নাম্বার
ভেতরে আছে।
Paragraph 4, my lord, your lordship.
By a writ petition, for by a writ petition, which being dismissed, comma, the order of dismissal was carried in appeal before an honorable division bench. The honorable division bench set aside the vesting order by a judgment
26.
dated 26th July 1996 in FMAT 1802 of 1992 and directed the state to pay compensation to the petitioner. Stop. The state preferred a special leave petition before the Honorable Supreme Court against the said order, which is still pending.
Still pending.
Still pending.
Which is pending. Stop. The Honorable Court directed both the parties to maintain status quo regarding possession on spot. Stop. Paragraph. Learned counsel for the petitioner submits that despite such order, comma, the state respondents have handed over the plot in question to the fifth respondent, comma, upon holding the plot to be vested. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard, annexing all relevant documents, and prays for a direction upon the authority to consider the representation at the earliest. Paragraph Learned Counsel for the respondents submits that who should consider?
But respondent number 5, my lord. Gale,
The competent authority.
competent authority, Gale, my lord.
No, but the vesting has been done by the.
That might be, my lord, but the
Should be the district magistrate.
then, my lord, both the authority will
Cannot consider.
then, my lord,
It's only been handed over to Gale. So
Gale,
Gale
my
has
lord.
nothing to do with
But the
the.
compensation will be paid by the Gale, my lord.
His claim, my lord, regarding compensation, the
Compensation.
Gale is, my lord, lying the pipeline.
So let Gale consider the representation.
I don't know, my lord, how
Gale,
it will be
Gale will pay the
considered.
compensation, my lord. Gale
His
will
claim regarding compensation. Gale will compensate regarding compensation.
Fifth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation along with all relevant documents before the fifth respondent within 2 weeks.
within 2 weeks.
Within 2 weeks from date. Stop. The fifth respondent is directed to consider and dispose of the representation within, and they are not represented also today.
I have, my lord,
Is
my
that
lord, already
clear?
handed over the affidavit of service, my lord, earlier day.
That will be 6 weeks. Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, commas, in accordance with law. Paragraph, the decision taken by the fifth respondent shall be communicated to the petitioner within a week thereof. Paragraph, since the fifth respondent is not represented, comma, the petitioner is directed to serve copy of this order along with a copy of the writ petition to the fifth respondent at the earliest. Disposed of which document? Along with the representation, submit these two also.
Within 2 weeks, my lord.
Yes. Copy of the order and.
Along with
Next.
For the petitioner. And in spite of direction twice, no report has been.
No, my lord, I have. এত রাগ করে কথা বলছো না এই দিদি একটু দেন না দিদি
না
19 নম্বর চলছে এই না 19 নম্বর চলছে যাও না উঠে যাও লড়াই করুন ঠিক করুন
Who is appearing for the railways?
My lord, that is the vested land is vested land, my lord. And that is, my lord, admitted by my learned friend, my lord. But without taking any process of West Bengal Land Reform Tenancy Tribunal, he is coming here, my lord. My lord, if your lordship will come, paragraph 2, my lord.
Of the report?
No, my lord. I must come. I have petition, my lord. Writ petition. Yes, my lord. Paragraph 2.
Yes.
My lord, that is the paragraph 2. That is P1. Page 17, my lord. This is his record, my lord. That is, my lord, 13 columns. That is Charu Chandra Pal, Pita Dharmodas Pal, Sang Nijo.
Yes.
In the right side, my lord, Patro Khotian 1362 সনের 31/4 পর্যন্ত বলবৎ ছিল। It is admitted position, my lord. Now, my lord, if your lordship come, paragraph 14.
Paragraph 13.
14, page 8, paragraph 14. My lord, second part, my lord, it is pertinent to mention that since according to the respondent, the subject land was vested to the state and therefore there was no requirement of acquisition of the land of the petitioner since the said land already belonged to the state of West Bengal pursuant to the vesting proceeding. But fact remains that your petitioner got the scheduled land on 28/3/1966 And whereas vesting proceeding was initiated in the year 1984 against the arsenal owner in respect of the self-same plot of land, which plot of land has already been transferred to your petitioner on 28 March 1963, far back from initiation of vesting process. So the vesting proceeding initiated therein has no manner of application in case of petitioner, and thus the same is not binding upon the vesting was there, my lord. But according to him, my lord, as he purchased before the vesting, so the vesting process was not. My lord, this court has not any jurisdiction of seeing this, my lord. Now, my lord, I filed the report, my lord. In report, my lord, I have stated everything, my lord, and the Khotian I have placed, my lord, in page 5. That is the Poschimbango Sarkar Pokke connector. Page 5 of my report. So, my lord, this petition is not maintainable. He must first, my lord, his vesting proceeding must be washed or anything else. After that, my lord, he may come before the honorable court for anything else. This writ petition is not maintainable, my lord. Yeah. Yes.
But kindly see what your lordship order dated 20th November 2023. First paragraph.
Yes.
The issue is decided in LR appeal. The plot of land is not under zone of vesting. The state was party there.
Where is this order?
Yes.
145.
121.
121.
Uh, 121.
Starts from 120 of the appeal court's order. Judgment.
Yes.
Cycle suit. 121.
The order in portion of 136.
This is in 2006.
Yes, yes. This is suit code order, appeal code 147.
In suit, my lord, here.
The suit was dismissed.
Yes, suit was dismissed. This one I could not produce the deed that was registered before initiation of acquisition process. Yeah, vesting proceeding. In the appeal court, I produced. That's why, my lord, page 146.
Yes.
The order at the bottom, my lord, that the appeal be and same is allowed on contest against the respondent number 1. Respondent number 1 is the state, my lord, and ex parte against the rest without cause. The judgment and degree passed by the learned court will is set aside. The appellants do get a degree in respect of the suit plots. The respondent is hereby permanently restrained from disturbing the possession of the appellant. The plot of land never.
Where is the memo of appeal? What was the decree that? Because it is only stated that get a degree in respect of the suit plots.
Degree, my lord, 148. Memo of the degree on appeal.
No, the memo of appeal where what decree was asked for. What did you see? Because the appeal says get a decree in respect of the suit plot. Decree of what? Only possession or title also? What is the decree? Your prayer in the
suit. Yes.
Have you filed the plaint?
Yes, yes. judgment of the suit
Declaration of title, permanent injunction and other consequential relief. The,
it has been declared.
yes, yes, Mr. Dev.
But his name was not corrected.
This is after vesting.
My lord, after that, yes, my lord.
Challenge
My
this.
lord, according to the provision of law, that is, this order has not any value, my lord.
Which order?
This order, that is the court's order.
Court's
That is
order
as
doesn't
because, my lord,
apply.
as because, my lord, he must go to the BLRO department to record his name.
You have not
Otherwise, my
challenged
lord,
the order, Mr. Dev. The
Yes.
state has not challenged the order. And it holds the field till date.
my lord,
Once a court declares right.
my lord, that is the record is there, my lord. First record is there, that is the arrest record. That was, my lord, the 1962 up to that, that was Bolovan. After that recording was then.
Has declared the title and possession of the petition.
My lord, he must go to the, to record his name.
He did not go anywhere. Have you? You have not challenged the order, the judgment. He
My
doesn't
lord,
need to go anywhere.
my lord, he must go to the, according to, he must correct the record.
Not a prayer for record
What
correction.
is your prayer in the writ petition?
Yes. Page 14, my lord.
Yes. Where is the impugned order?
Impugned order. Page 163.
163.
The reply of the RTI. They have utilized the land. The acquisition process has been never been initiated.
No, you're referring to some reasoned order on the basis of representation. Prayer
Lord,
A.
I asked for, they have not supplied the reason order, only reply has been given.
The representation is still pending.
No, they have considered my representation, they have replied that. Or kindly see, Madam.
RTI is different. You have asked, you have talked about a representation.
I have made RTI application for query the outcome of the representation, a reason order. They have not supplied the reason order. They have only response this.
Oh, they have stated application has been turned down.
Yes.
That's all.
And the plot is used for construction. Acquisition process never initiated. No.
Yes, Mr. B.
But their case is
But there, if he challenges the RTI, my lord, then he must go to another forum. There is a provision of appeal.
I am not challenging the RTI. I am just.
In the
And
RTI, it is said that his representation has been turned down.
Yes.
No
Then,
reason.
my lord, then he goes to the appeal. That is the provision of law. That is the provision. This
He
is
is not challenging the RTI reply. If he challenges the RTI reply, then there is a
Yes.
petition for appeal.
my lord, he filed an
The representation.
representation.
No hearing was there. He was not called for a hearing. No order was passed.
Then, my lord, representation will be considered by the authority.
No, my lord, my lord, my lord.
My lord, two things, my lord. If he challenged the RTI, my lord, then RTI, there is a proceeding of appeal.
He is not challenging RTI. Since nothing was done with his representation, he filed an RTI to know what happened to the representation. The authority says
Yes.
your representation has been rejected.
Yes.
A one-liner.
Yes, my lord.
But where is that rejection order? Where is the rejection order?
Page 150.
अरे वो तो पाई नहीं उसी का ही तो बोलते हैं
वही तो एनेक्स पूरे
हाँ
हियरिंग है जो लिटिगेशन लैंड एप्लीकेशन
I filed the representation, LA collector heard me, passed the reason order. They have stated that my application has been turned down. I have challenged that turned down order.
My lord, I must give him the copy of the same, my lord, your lordship.
See, that has to come before the court also because
Yes,
we
ma'am.
do not know what is there in the order. Whether it is
Ma'am.
a reasoned order at all. That has to be looked into.
My lord, that will be
That's
considered
why your
in the
lordship
time.
directed twice to file separate reports.
That was the reason for
Earlier occasion they said compensation has been paid. Now they are vesting.
Compensation has been paid.
Yes, earlier occasion
हमारे तो report ही नहीं compensation has been paid.
your submission was there.
है नहीं किधर? My lord, that is a very vague submission. As because I have nothing to say in this matter, and I am telling without report, I must say that
no money.
On the earlier occasion, Mr. Day's submission was that if the land has been utilized without acquisition, the requiring body should either propose direct purchase or set.
Yes, my lord, that is the procedure, our procedure.
Send a
He
procedure.
had. But now we are seeing that there is some difficulties as because vested land was there.
According to them, this is vested. According to me, this was not under vesting. As per title appeal order. And even then, the railway is under possession.
Because it is in 2006.
State was
It
party.
says that the petitioner is in possession.
But my lord, he filed an application that applied no consider. The hearing was there, my lord, 158. If your lordship will see,
That
one
petitioner admits.
158, my lord.
Where is the order?
That order is the, my lord, he must
That is
get
not
that order.
Yes.
He must get the order and he will challenge that order, my lord.
He has challenged that order in the writ petition.
He has not challenged that order.
Prayer A.
Where is that order? Where is that order, my lord? If he challenge, that is the, if he challenge that, how he challenge? That is the no order is there.
He has stated that in his prayer A.
Prayer A, my lord, that is I read in the nature of mandamus directly in the respondent, particular respondent of 3 and 4, shows as to why after I reply, after and after, followed the reason order passed on the basis of representation made by the petitioner dated would not be set aside to us. My lord, there is no any order in the, but they challenge that.
So he has, yes, because there is one line that it has
Turn
been
down.
rejected. He has been informed that it is rejected. He has not been served with a copy. The report should have been there. You should have annexed that order with the report.
But that is not the order. That is the one line order, is not the.
This is their order. This is their order.
My lord, they,
Kindly.
he must pass the reason order, my lord.
Please produce the order before the court, since it is said that it is turned down.
Or otherwise, he will get, my lord, within certain time, he will get the order.
I think it will be better if it is produced before
Yes,
the court, since the matter is pending.
Yes, ma'am.
Report in the form of affidavit submitted on behalf of the state respondents. Do you have anything to add?
As
Mr.
for the
Ghosh?
railway, madam.
Yes, do you have anything to add?
No, my lord. Actually,
Let
madam,
the order come before the court. We do not know what is there in the order.
madam, railway has nothing to do with this matter. And my lord, they have no allegation against the railway.
Railway is under possession without acquisition.
You have been given vested
Actually,
land.
my lord, railway got the land from the state of West.
Yes, yes.
If the land is not vested, certainly you will get the compensation.
Yes, yes.
From the
It
railway.
is to be decided by the land acquisition collector, madam, not by the
Not the
railway.
railways, absolutely,
Yes.
absolutely. Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph. It is submitted on behalf of the petitioner that in reply to an application made under the Right to Information Act, 2005 by the petitioner, the petitioner has been informed by the State Public Information Officer and Special Land Acquisition Officer, HON'BLE, that the representation submitted by the petitioner before the authority on 20th June 2022 has been turned down. Stop. Copy of the representation has not been served upon, copy of the order.
Reasoned order.
Copy of the reasoned order has not been served upon the petitioner. Paragraph, the state respondents are directed to produce a copy of the reasoned order passed with regard to the representation submitted by the petitioner on 20th June 2022 on the adjourned date. Paragraph. Let the matter appear under the same heading on 19th February.
Yes, ma'am.
Sorted there.
They have to collect the reason order. Let them come back.
I think, but this is ready. Reason order should be ready.
Let us see.
No, if the authority will correct, if not pass, and in that case, if the authority will pass the fresh order,
Not necessary, because the RTI reply, the authority
Yes,
says
turned down.
it has been turned down.
they have stated.
So that means there is an existing reason order.
Yes.
Well, let there be a shorter date, in fact. Let it appear on 8th February. Sit it.
Yes.
Wait, sir. Next.
Yes, matter 600.
600 loss. I am appearing for the petitioner loss.
My lord, I am instructed to appear on behalf of the private
Please, sir,
respondent number 10.
Lordship appearing on behalf of state respondents.
Yes. Please, sir, stay with me.
এই কাগজ দিন না এখানে নাম লেখার কাগজ নেই গতি কি করে কাগজ রাখুন
Yes, what is the matter?
Yes. Lordship, fact is that petitioner claiming private respondent encroaching the PW roads land in front of the petitioner right land. Due to such encroachment, petitioner cannot construct his residential house, though it was converted from up to the Bastu land.
Encroaching the land?
No, PW roads land. PW roads land in front of my right land. I made an application before the authority concerned. Thereafter, authority concerned issue a letter to the concerned BLRO to inquire the matter. But as per my instruction, inquiry was completed as per my instruction, but thereafter no steps was taken. So that Lordship kindly direct the authority concerned. If any encroachment is found, then the proceeding as per the proceeding.
BLRO has demarcated the land, Lordship.
Yes.
Demarcation is over.
Yes, yes.
Have you initiated proceeding?
Initiated not proceeding because this is the BLRO step he has taken, that is only a
Encroachment আছে না নেই বলে
I draw Lordship's attention, page 3, Lordship.
So you have found an encroachment, isn't it?
Lordship, page 3 is the 210, second column, Lordship says detail of the unit picture, marker division of Dr.
Raman.
Dash. Mr. Bhandar is also there and club is also there, but the error plot is 210I839. Adjacent to Egra, Bajpur, Pakka Road. Page 3, Lordship.
Yes, yes.
And there is 211. Their plot. Last
Two
page
is
also.
the petitioner's plot. So should be adjoining.
Sketch map is also not last page 7. Sketch map. And it was so much interesting. Just today I got.
Have you initiated proceedings?
Proceeding we have got initiated, only demarcation process.
Let proceedings be initiated. Yes, anything to add?
Yes, my lord, my lord, deeply obliged before your lordship. My lord, there is, so far my client is concerned, respondent number 10. I have neither encroached any land of PWD nor constructed any room or shop room there. Kindly record this and my lord, let direct.
Nothing to worry.
Yes. No, nothing or yes. I do not kindly record my statement, my lord, and your lordship. Yes.
Let the authority initiate proceedings.
That is only.
I am not appearing on behalf of the respondent number 9.
You're not appearing on for 9. You're appearing for
Only 10. That is why, my lord.
Yes, sir. All the respondent was sub.
9 is not present, Lordship. Mr. Bhandar.
9 is encroaching.
রিপোর্ট কি বলছে আপনার
Not encroaching, Lordship. LR plot is 210 and petitioners is 211.
Yes, so it is in front of the petitioner's plot.
So PWD's land, only one Mr. Bhandar it is that marked as C.
That is exactly the case of the petitioner. He has not said for once that his land is being encroached. So, affidavit of service. Paragraph none appears for the 9th respondent despite service. Paragraph. The petitioner claims to be the owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road.
Lordship, Mr. Bhandar and Clark are in the state.
I have seen this, madam. Let me pass an order, please. by encroaching upon a portion of PWD land adjoining his property, thereby obstructing his egress and ingress. Paragraph. The petitioner submitted a representation in this regard before the concerned authority on
Lordship, page 20, it was made on 22 8 2023.
on 22nd August 2023, pursuant to which demarcation of the plot in dispute has been made by the block land and land reforms officer. Stop. The petitioner submits that no further step has been taken by the authority. Paragraph. Learned counsel for the private respondent number 10 submits that this respondent has not encroached upon any portion of the PWD land
Or constructed, my lord, any room, any shop room.
or raised any construction.
আপনি শুনুন না কি বলছি আগে, তারপর তো বলবেন। জজ সাহেব অর্ডার পাস করছেন।
Learned counsel for the state respondents submits that submits a copy of the demarcation report along with sketch map and learned counsel for the state respondents places reliance on the demarcation report and sketch map and submits that a portion of
কি হচ্ছে পয়সা বাঁচাচ্ছিস পাশাপাশ করে নিচ্ছি
plot in dispute has been encroached upon by
এই জন্যই বলেছি দাদার মুখে যোগ্যতা পাশে
the 9th respondent who runs a shop therein.
জজ সাহেবকে বলবো মানে দাদা কি পয়সা সার্ভিস করেছে বোথ সাইড জেরক্স
Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since encroachment upon PWD land by the 9th respondent has been found upon demarcation, the concerned authority being the third respondent here be directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
Since my lord, it has been disposed of and motion stays, kindly the record that yes, it is not
The usual land which is recorded.
lost, deeply obliged.
Yes. Next.
And for the petitioner, Mr. Chittapriya Ghosh is leading me in this matter. This is the affidavit of service, and I have mentioned the matter after giving the notice.
I'm for the state, Your Lordship.
My lord, the big fact of the matter is, Your Lordship.
Other respondent?
Other respondent, I have also served them the prior mentioning notice. This is the copy of the
Sir,
email.
copy of the petition to the Pradhan.
Yes, Your Lordship. Yes, Your Lordship. In the affidavit of service, it has been stated that the item has been delivered.
Yes, sir. Yes, sir.
Now, Your Lordship, the fact of the matter is that the local video, Mr.
Continue, please. Yes.
The local video has started construction of a purified water project upon my land, Your Lordship. And I have raised several objections with regard to that. I have filed a representation before the concerned BDO. I have filed a 144(2) proceeding that order has been also served upon the BDO, but they have not served. And while the matter is pending before Your Lordship, as soon as I have served the notice that the matter will be mentioned and it will be upgraded, they have completed the structure without taking any consent from me, without acquiring the property. Nothing has been done, Your Lordship.
So are you actually asking for compensation since?
No, my lord. I am the player is that my lord, Mr. Ghosh will.
Yes.
My plot of land is
Yes, what are you asking for? Since this is a public project.
No, well, there must be there may be a public project, but public project cannot be done by and force. This is completely by and force.
Seeking
But
demolition or
yes, demolition.
compensation?
Demolition.
My lord, only I have received the verbal, my lord, instruction. My lord, if your lordship kindly take the annexure 1, the name of the, my lord, person, my lord, it is Shunil Kumar Mondol and not Mr. Prabhat Mondol. My lord, I have been instructed. The owners have already given the no objection.
Sunil Mondal is the father of the petition.
My lord, the petitioner's father name is different, my lord, as per their affidavit, my lord. That is Jyotin Kumar Mondol.
Kindly come to the cost title.
Jyotin Mondal.
Tell-
Jyotin Mondal is also there, petitioner number 3.
My lord.
3, 4. This is a joint family property, my lord.
My lord, I have been instructed that no objections have been given. My lord, may I then come back with proper written submission? My lord, may I come back with, my lord,
In
may
the
I
meantime,
come
my lord,
back?
not to proceed further.
Do not proceed any further.
My lord,
right?
my lord, I informed them, my lord.
Affidavit of service. None appears for the 8th respondent despite service. Paragraph. It is contended on behalf of the petitioners that the BDO is doing it,
Yes, my lord.
that the block development officer, Tactile block has raised construction of a purified water reservoir in the land belonging to the petitioners without their consent. Stop. The petitioners seek demolition of the said structure. Paragraph. Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 19th February.
Lordship.
Paragraph. The state respondents are restrained from raising any further construction or utilizing the land of raising any further construction in the land of the petitioners or utilizing the same any further
Much obliged.
till 29th February 2024. Please annex the relevant documents.
Grateful, my lord.
Much obliged. Yes.
Under the motion. Next.
I am for the respondent. I have simply Great read with your respondent, my lordship. lord. I'm a senior citizen widower, my lord. I'm a tenant, my lord. My landlord is not accepting the tenants, my lord. I have taken out an application. I'm depositing the rents with the rent controller, my lord.
No,
Now,
you
my
are
lord,
not
in the
depositing.
meantime, my lord, what has happened? Your lordship kindly come to page 87 once, my
Who
lord.
is appearing for the private respondents?
My lord, I have served, my lord.
Yes, the service.
দুটো চলে গেছে Mala, they have received Mala on 5th of January, Mala, they have received.
Party. Who is the party?
Mala, all delivery confirmed, Mala.
Yes.
My lord, if your lordship kindly come to page 87 once, my lord, of your lordship's brief, my lord. My lord, this is the application, my lord, which I have made before the rent controller, my lord, for carry out of essential repairs, my lord. My lord, they have refused to accept the same. I have sent it through post, my lord. Your lordship kindly come to page 89. Is a postal receipt, my lord. And my lord, page 90 is the record which shows, my lord, it has been delivered to the concerned authority.
Yes.
Now, my lord, I only beseech your lordship, my lord, let this application be disposed of, my lord.
Your Lordship, kindly appreciate one thing. During the midst of this pendency of this proceeding, my Lord, there's a theft taken place. Your Lordship, kindly come to page 83 of my application.
83?
83.
Yes. This is an FIR.
Yes, my Lord. Not after this, my Lord, again, on last Thursday, my Lord, my bicycle and my utensils has been taken away, my Lord. Police.
You are still occupying the.
No, my Lord, I cannot because the window panes are broken, the doors are broken. My Lord, kindly see the photographs, my Lord, which is appended to this application, page 91, 92, and 93. My Lord, my daughter is married while she is staying in Kolkata, my Lord. My son is married while he is staying in Malda. Now, my Lord, I'm shifting my houses, my Lord. There are, my Lord, the things, my Lord, which has been taken away by the thieves, my Lord, in the broad daylight. I only, my Lord, beseech the authority, my Lord, to consider my application. It may be rejected or allowed, whatever it may be, my Lord. Let them take a decision, my Lord.
My Lord,
From October till date, my Lord, it is pending.
petitioner made application before district magistrate, my Lord, not rent controller. It is not a government property. It is a private property, my Lord. And
87 is before the rent control.
Rent
rent
control.
controller, but they make
My Lord,
party the
my Lord,
district magistrate, my Lord.
I pray for leave, my Lord, for correction of the.
Yes, my Lord, they didn't made a party rent controller here.
No, my Lord. Respondent number 4 is the rent controller, my Lord. Subdivisional officer acting as a rent controller.
But you made your abandonment saying that you made application before respondent number 3.
Subdivisional officer, Malda, ex officio rent controller.
No, but you made application before respondent number 3.
No, I have made respondent number 4. It had to be Indian.
87 is for the rent controller.
Rent controller, my Lord. My Lord, leave may be granted, my Lord, to correct the prayers, my Lord. Your Lordship, kindly, my Lord.
In prayer portion, they are also praying for direction upon respondent number 3, my Lord.
My Lord, leave may be granted, my Lord. Instead of 3, it will be 4, my Lord. My Lord, I only beseech you, let them take a decision, my Lord. Giving hearing to all the concerned parties, my Lord. I cannot stay there. Your Lordship, kindly appear. I am 73 years old, my Lord.
So let the fourth respondent dispose of the application within 2 weeks.
My Lord. By giving a chance of hearing to me, my Lord.
Absolutely.
And my Lord, they should communicate the order also, my Lord. Because the way, my Lord, they are acting, my Lord, it violates the law, my Lord. They have.
The direction should upon the respondent number 4, my Lord.
Yes.
My Lord.
Affidavit of service, paragraph, none appears for the private respondents despite service. Paragraph on prayer of the petitioner. Leave is granted to amend the leave is granted to incorporate respondent number 4, inverted comma rakho, in place and stead of respondent number 3, it in inverted comma, in prayer A of the writ petition. Stop, the prayer be amended accordingly. Paragraph. It is contended on behalf of the petitioner that an application filed by the petitioner before the fourth respondent seeking permission to effect essential repairs to her rented premises.
আমি পুরো বডিটা 3 করেই লিখেছি বলেছে
has not been considered by the said respondent till date. Stop. The petitioner prays for a direction upon the respondent to consider the application. Application for repairs. Application for consider the said application at the earliest. Paragraph. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the application submitted by the petitioner dated.
My Lord, it is dated, my Lord, 3rd of October, my Lord. My Lord, we have sent it, my Lord. On 3rd, it has been received by them on 4th of October.
4th October. Oh, you can't read the
Dated 3rd October 2023. Within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing, who are the private respondents?
And my landlord, my lord. They are not accepting the rent, even they are not coming forward, man.
Upon all concerned, including the petitioner and the private respondents, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Well, only one thing, Lord, to kindly protect me. If they do not appear, my lord, but they will not appear, my lord. In case, my lord, they do not appear.
I have said upon opportunity of hearing. Opportunity of
opportunity
hearing. That means service of notice.
My lord, I will serve them, my lord.
After that, if they are not appeared, then
My lord, they will dispose.
Grateful, man.
Grateful.
Petitioner? Yes. Have you served?
I'm appearing.
You're appearing for all of them, all the respondents. Yes, what is the matter?
My lord, praying for Passover. Senior is engaged.
Make your submission. I'll help you. Yes, what is the matter? Take these opportunities.
Opportunity পাবি এরকম opportunity পাবি কর
My lord, the petitioner started a business under the name and style of Hotel Appen in Katwa Court premises. Then SDO
There was a written permission to run the hotel.
Pardon?
Was there a written permission to run the hotel?
Yes, my
Did the
lord. We have the
petitioner take
license. We have the license. After that, the SDO stated that to
Yes, he has received a notice from the SDO. Paragraph 9 of your plaint. Come to paragraph 9 of your plaint, please.
9.
The application, yes. Paragraph 9.
Paragraph 9. Your petitioner states that suddenly a notice under memo number 56 LESDO CAT dated 8 January 2024 issued by the Sub-Divisional Officer Katwa, Purva Bardhaman was served upon the petitioner, which directed the petitioner along with the several other persons to show cause as to why a proceeding under section 4 subclause 1 of the West Bengal public land would
You have challenged this notice, isn't it? Yes. You were called for a hearing by the authority. Then what happened? I find that you were called for a hearing.
Page
Paragraph
42.
11.
Page 42, Lordship Kindness.
42.
Yes, this is a hearing notice.
This is a hearing notice. Hearing was conducted on 16 January.
The order-
Thereafter, my order has not been passed due to they have not produced any of the document. Thereafter, another time was given. Today is the fixed for hearing date. But it is totally premature. So cause stage where there is a provision for appeal also section 7. And here, my lord, he is. তুমি বলে দিয়েছো আমি বলবো I said something. My lord, he is, my lord, obtaining the license from the judicial department, that is DAG number 605, DAG number 606, which is totally, Lordship kindly see the BL
But
report.
this is 605.
This is 605. This 605, they are occupied 605, but 606, only judicial department. This is my error report, Lordship kindly see.
Well, Mr. Devra, today, since date has been fixed today,
Hmm.
let the petitioner appear with all the documents before the authority today.
Yes,
Let
yes,
there be
yes, yes.
another date in the writ petition. Let it be adjourned for some time.
No, no question urgent. Even there is a provision for appeal also. My lord, paraphrasing lordship kindly see.
There is,
This
but
is-
I do not want to dispose it of today because her learned senior is not there today.
But that is the
Let us not
another.
embarrass the junior.
No, 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 no.
So let there be a date.
Lordship will record it, my lord.
Hearing. Please instruct your clients that they should. produce
Lordship
all
will record because
the authority
with all the documents.
Grateful Lordship.
heard learned counsels for the parties. The petitioner has the 8th January notice has challenged the notice issued upon him in terms of section 3 within bracket 1 of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act 1962 on 8th January 2024. Paragraph learned counsel for the petitioner, learned counsel for the respondents submits that the matter has been taken up for hearing by the concerned authority, and since the petitioner was unable to produce any document before the authority on the earlier date of hearing, he has been granted further opportunity to produce relevant documents in support of his claim, and date of hearing has been fixed today. Paragraph in view of the above, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th February. Please advise your clients accordingly. Produce all the documents for the authority today.
Okay, Lordship.
Next.
Only instead of today, my lord, lordship let it skip hearing fix and fix 9. Fix the edited because today is the chief minister is visited the place.
Hearing today. You said that
today fix. Today is the fix, but
the
subsequently it will be adjusted.
No, it will be, but now till now.
No, till now.
Remain.
That is my goal.
If it is adjourned, please inform the petitioner.
Definitely.
Next, 604.
My lord, I beg to appear on behalf of the petitioner.
I appear for respondent number 2 and 4.
And I was respondent number.
My lord, affidavit of service.
Here for the Indian Hall.
My lord, I am seeking leave to file affidavit, my lord, with regard to the petition, my lord.
Is it necessary?
Lordship.
It is necessary, my lord.
Lordship, it is.
You are appearing for?
For Union of India, my lord. That's for number 1.
What is the matter about?
My lord, I am the owner of a particular plot of land at Holdia, Purba Mednipur. And my lord, the land is a Bastu land. My lord, being a Bastu land, my lord, I saw sometimes, I saw that at a distance place from my land, on a different plot of land, one placard, there is embedded one placard on the land saying that IOC pipeline is going on, means under construction. My lord, seeing that placard, it is not on my land, it is distant, at a distance land. Seeing that, my lord, I have preferred an RTI to the IOC that whether any pipeline or any petroleum or mineral pipeline is running underneath my land or not. And this is the description of my land, specific description I have given. My lord, they have categorically said no. My lord, I have annexed that RTI over there. My lord, they have categorically said no, that there is no pipeline is running underneath that. My lord, after getting that reply, my lord, I have gathered construction material on my land to construct a building as per the sanction of the local panchayat, my lord. Now, when I have gathered the land, when I have started construction, my lord, police came along with the IOC people to stop me and restricted me to enter my land, and said that no, that mineral and petroleum and mineral pipeline is running underneath your land. Then, my lord, I have said and I have represented.
It's already running or it is proposed?
My lord, I don't know. I don't know, my lord. I don't know.
Already laid down.
My lord, at the same time, my lord, they have said that there is no pipeline is running underneath my land, my lord. Now, my lord, my prayer is that, my lord, since no acquisition has been done and no, as per the reply of the RTI, my lord, they have what they have given, that there is no acquisition and there is no pipeline is running under my land. So, my lord, why can't I, my lord, I am asking myself that why can't I use my land for my residential purpose, since it is the Bastu land and I require that land for building, my lord, for accommodation of my family.
Yes.
Lordship, some facts are required to be brought before my lord. My lord, as of today, my instruction is, my lord, the subject plot, my lord, is already sub judice before the civil judge junior division Holdia.
My lord,
Subjudice with regard to what?
My
my
lord,
lord, there is a different, my lord, my
subject plot.
client, my lord, I am clarifying, my lord. My client has preferred a title suit on a against them on a completely different ground. My lord, even if my client has filed, that doesn't have any legal value because section I have mentioned it in my writ petition. I have not suppressed, my lord. Even then, my lord, section 14 of the petroleum right to use acquisition and right to use land, it says that civil court is barred by jurisdiction. So, my lord, whether it is filed before the civil court or not, my lord, we are on the process of withdrawing, my lord. After filing, we are on the process of withdrawing because, my lord, my client has suffered a substantial financial loss due to them, my lord, because my lord, my lord, gathered building materials, getting permission for construction of building.
Affidavits will be required. Why don't you come back with a report in the form of an
Lordship.
affidavit? Yes.
Lordship.
Annexing all the relevant
My lord.
documents. Since your document says that no pipeline is
Lordship.
running
Lordship.
through this land, right?
My lord.
And in the meantime, please take steps for withdrawal. Because two
My lord, I will, my lord, my lord.
cannot continue.
No, my lord, it is anyway barred by law. It is anyway barred by law, my lord. Yes, my lord. Yes, my lord. It will not affect this writ petition, but I'll just.
And have you
My lord,
served the
annexure
state?
P4 is the particularly the RTI, my lord.
It is there. Have you served the state?
My lord, I have Union of India, my lord, and I have served the police also. Bhawanipur police station.
So no one is appearing for the state in this matter.
No.
Someone would appear.
Lordship.
Mr. De, any one of you have any? Yes, sir. Please serve a copy to Mr.
My lord, I'm serving right now, man.
Affidavit of service. None appears for the state respondent despite service. Paragraph is for rigorous service.
My lord, I have served a copy upon.
I have regularized his appointment because the state needs to be represented.
My lord.
The petitioners.
So, my lord, responder, I have made a party, the police.
Yes, I've seen that. Yes. That's why someone has to be represented.
Yes, my lord. Yes, my lord.
You have served, but there's no one representing the state.
No,
So I've requested Mr. De to
My
appear.
lord, my lord.
The petitioners seek a direction upon the respondent authorities. But the petitioners seek a direction restraining the respondent authorities from raising any obstruction to the construction made by them in their own land. Paragraph Learned Councils for respondent numbers 1, 3, and 5.
2 and 4, my lord.
I'm for what?
So 1, 2, and 4 will come back with reports. Respondent numbers 1, 2, and 1.
One, coming we put to the order. But kindly delete one because whether kindly consider whether Union of India should file a report or not.
My lord, IOCL will file the report.
We must add one, that is the competent authority of the, competent authority is not a party of the person. Competent authority will do all the things.
Respond number 2 to 3, 2 to 4.
That is the Union of India and other things, my lord, or bill. They are but competent authority, our, my lord, sometimes the special land acquisition officer or additional district magistrate. Special land acquisition officer will be the competent authority.
No, but this is not acquisition, laying of pipelines.
Yes, my lord. For that is, my lord, all the matter.
Because notification
what-
was published in
what-
official gazette in 2019
By the competent authority.
by the competent
So
authority.
please,
Let them add parties. I appreciate Mr. De because rightly pointed out.
who is the competent authority here?
My lord,
And I don't know
sir,
whether
a special land acquisition officer,
So whom will he implead in the?
my lord.
special land acquisition
I
officer.
haven't received anything from any side, my lord. All I received is their reply to the RTI. My lord, Annexure 4.
It's, affiliate also. My lord, special land.
Annexure 4, my lord.
Special land acquisition officer. Let
He
him
must be
let
added,
him
my
be
lord.
added.
My lord.
ওটা একটু শুরু
ওই তো সব
করুন।
তোমরা তো
On
কিছু
prayer of
সব করবে,
calculation,
calculation.
comma liberty is granted to
On behalf of
implement the
ISUL equipment.
Yes.
special land acquisition officer,
Competent authority, that is special land acquisition officer.
implead the competent authority, comma, the special land acquisition officer. Holdia,
Yes, ma'am. Special land acquisition officer, that is
as respondent number
special land.
6,
পূর্ব মেদিনীপুর
special land acquisition officer, Purbo Medinipur. As respondent number 6 in the writ petition, the constable of the writ petition, we amended accordingly. 6 to submit learned counsels for respondent numbers 1 to 4.
2 and 4, my lord. 2 and 4 IOC.
I'm for one. One is,
Union will not submit a report.
no, not if this, because land had been
That will
acquired,
be sufficient.
no, not I think so. Let the report come. If
Is it
necessary, we'll act.
Come back with the report.
That is the only my lord required, only my lord, that is not any acquisition. Only my lord, you use that land, user. Yes, my lord, I can file a report. My lord, no.
Let special land department should file a report because land had been acquired on behalf of
4 also needs to file a report.
That's why my lord, user.
but user.
Only user, use code.
Yes. Learned counsels for respondent numbers 2 and 4, as well as the state respondents. 2 and 4, as well as the state respondents, seek to submit reports in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 22nd February.
Time
Yes.
Lordship, this is my contempt application, Your Lordship. Lordship, it appeared earlier also, and yeah, the affidavits were exchanged. They've already filed their affidavit. Yes, they filed the affidavits, and our affidavit in reply is also ready, Your Lordship.
কোল ইন্ডিয়াকে সার্ভিস করে নাকি
সবাইকে করা আছে
কোল ইন্ডিয়া অপোজিশন আমরা অ্যাপিল করেছি অর্ডার এগেইনস্টে
My lord, I am for Coal India Limited. We have preferred a special leave petition against the order dated 26 February 2019. That is still pending before the Supreme Court.
No, but that is not the case. Our contempt is against the CMD of Central Coalfields, Your Lordship. Yeah, no, the order is against the order dated the 26th of February 2019. Absolutely. So SLP is pending, Your Lordship. What has happened? I'll just give you the brief facts, Your Lordship. Lordship, the issue involved was basically imposition of excise duty on royalty and stowing charges. So the supplies which were made by the coalfields, Central Coalfields and all to us, they were not imposing any excise duty on royalty and stowing charges because they felt that royalty was nothing but a tax. Now, this issue subsequently was pending before various courts, ultimately was pending before the Supreme Court, whether the royalty is actually a tax or it is not a tax. Now, meanwhile, Your Lordship, we filed meanwhile, the Central Coalfield demanded that we deposit the entire amount of excise duty which was raised on by the excise authorities on the coalfield. So against that, we filed a writ petition before Your Lordships. And the Lordships, in the writ petition, passed an order dated the 11th of April 2014 that an undertaking indemnity should be provided to the court. Against that particular order, Your Lordship being agreed, we filed an appeal. Now, appeal which is before Your Lordship was of 26 February 2019, where it was clearly held by Your Lordships that no, the question of indemnity does not arise. And I will just take you through the respective paragraphs in this regard, Your Lordship. Kindly have a look at it, page 115.
Unfortunately, the file is not there.
Oh, okay. Okay, I'll just read it out. After the order is made, it is submitted on behalf of traders. Those traders who continue the transaction with the coal companies are suffering since their subsequent payments have been deducted towards the shortfall. In view of this, the coal company shall not make any recovery of the excise duty claims in respect of the past transactions for the period indicated. And in this, Lordships clearly held that no indemnity is required to be given. Now, the coalfields have not challenged this order. Now, meanwhile, the Central Coalfields started, we were supposed to recover about an amount of 1,61 lakhs from the Central Coalfields. Now, they started demanding that you deposit this money of 45 lakhs with us, otherwise we will not release this money. And they relied on an order which was passed by the Jharkhand High Court, where we are not even parties to it, Your Lordship, which they've annexed to their affidavit. Now, ultimately, out of compulsion, we said that, okay, we are prepared to deposit this amount of 45 lakhs with you, 45 lakh 98,000, but you please release the balance amount of 1,61 lakhs. Now, subsequently, Your Lordship, the appeal, of course, has been pending before the Honorable Supreme Court. Meanwhile, after this order was passed by Your Lordship, we requested the coalfield that now please return our money, because of the fact that this order is in a very explicit order that we are not supposed to make any deposit or give any indemnity to you. No, they have not responded at all to this particular demand or have refunded back that amount of 45,90,000. So this is absolutely. So this is why we have filed a contempt application against.
This order has been carried in it's pending. You can serve with the notice and show. So let us.
But I'm on.
Numbers 3 and 4. Yes, my lord, against the my lord, Southeastern Coalfields, my lord, and my lord, Dr. Anurag Garg is the contender, my lord. There he is the general manager, my lord.
One single order which has been
on a common order, my lord.
Yes,
Common order. So, my lord, both by the-
I'm only praying, your lord. I'm only praying, your lordship. The appeals are pending. There is no otherwise. I don't think there are any particular orders passed by the Honorable Apex Court. Now, our amount has been lying stuck for more than quite some time, your lordship, of 45,98,000. At least direction should be given to the coalfield to release this money because of the fact that this order has attained a finality. Because but your lordship, this order has attained a finality. This appeal court order has become a finality because they have not appealed against the appeal court order, your lordship. They have not appealed. No. They have not appealed against this order at all, your lordship. This order of 26 February 2019 has not been appealed. No.
My lord, Coal India has appealed before the Honorable Supreme Court.
Against which order?
26 February 2009.
Okay, they have appealed against this order. So, but my only point of contention here is, your lordship.
I'm sorry, I think that's.
No, lordship. Lordship, may I just kindly address one point, your lordship? There is no stay granted by the Honorable Apex Court, your lordship.
Stand, sir, but there's still the Honorable Apex Court is inside. Let us wait for some time.
Lordship, this is Lord 2014-15 matter, your lordship.
March,
Lordship, but my only prayer.
Malad, the initial matter is pending before the 9 judges bench, Malad. Whether royalty is taxable or not, Malad, that is pending before the 9 judges bench. And Malad, the order against the contempt has been appealed against. Malad, against the order of Justice Banerjee and Malad, Division Bench of Justice Banerjee, Malad. Against that order also, Malad, the Coal India Limited, Malad. That is pending before the Honorable Supreme Court, Malad. So, Malad, until the 9 judges bench is heard, Malad, this will be kept pending. But my lord, the thing is, my lord, our money, which has been asked to be released, my lord, not to be withheld by the this direction was passed by the Honorable Single Bench as well as by the Honorable Division Bench, my lord, that the past transactions will not be withheld, my lord. That has not been complied with, my lord, and they are still a huge amount, my lord.
That is what exactly we are saying, your lordship. See, lordship, kindly one issue. Lordship, lordship, we have given, lordship, kindly, one moment. Lordship, we have given already an indemnity of 45 lakhs, and indemnity has already been provided to the Central Coalfield. But over and over the indemnity, they are further demanding that we have to pay 45 lakhs.
There is no stay order, my lord.
No.
Stay order by the Honorable.
Know that, we've seen that. And that's why I'm not delisting it. I said matters of March. In the
Okay, I'll.
I mean, early direction is
submitted on that the order under proceedings in the budget is March.
Lordship, one submission I just like to make, your lordship. As far as I am concerned, your lordship, I have already given them an indemnity. And over the indemnity, they have further taken 45 lakhs. I'm grateful, your lordship. Right. But the Supreme Court, lordship, the fact is, we know how the Supreme Court is, with 9 benches, when are they going to sit together to decide on this matter is a question. But this point should be taken up on the next hearing, your lordship, about my plea, my submission, that already an indemnity has been provided. Then in that case, by 45 lakhs should have been released. That's all, which I've actually physically paid to them. I've given a double insurance to them, which they've demanded. No, the point which is pending before the Honorable. No,
The entire facts will be placed
absolutely.
at this moment.
No, I truly.
Please wait for some more.
Okay, absolutely. Grateful.
In this matter, I am appearing on behalf of the petitioner and led by Mr. Aurobindo Chatterjee. In this matter, the calculation of the tax and additional tax to be served by the But you kindly just now I received it. Kindly pick the matter on Monday. That's the
Assessment, face assessment, lordship. In terms of your lordship order, face assessment was made. Lordship.
Kindly,
You want to go through this and come?
yes, Lordship. Yeah. Kindly pick the matter on Monday, Lordship. In the meantime.
I have handed over the copy of it.
Yes, Lordship.
Yes.
Oh, I am just now I have given. Second.
Fresh assessment on behalf of the respondents is taken on record. Paragraph learned counsel for the petitioner seeks to peruse the same. Paragraph let the matter appear under the same heading on 7th February.
On 7th February, I have some personal.
9th? 9th. Next. Dada.
Yeah, 9th.
80.
In this matter, my lord, lordship direction was file a supplementary affidavit. My affidavit, sorry, after report. My report is ready. My lord, people, my lord, person concerned may come from Kujbihar. He is on the rail. Today morning, I talked. His at evening, the train will be reached in Howrah. So,
my lord, short date and my lord, another my lord, also my lord, upon ourselves as a directions, your lordship, that the person who purchased the vehicle,
Have you served the
but
identity?
that has completely not done, your lordship. Kindly grant the extend the leave so that it has to be endorsed. And any other day, your lordship fix. In the meantime, I will.
Leave is already granted. There is no time.
That has not been done yet. My lord. And it has been served upon this, my lord.
Upon the other respondent.
So on prayer of both the parties.
My.
By consent, on prayer of both the parties. On prayer of both the parties, the matter is adjourned. Paragraph let the matter appear under the same heading. This is Kujbihar. You have to serve at Kujbihar.
Yes.
Kujbihar.
On 12th February.
Mile.
You can serve by then.
Mile. But the amendment has to be, my lord, here and now, my lord, Mike.
Next.
The march of
81.
well, I'm for the petition. Oh, Monai Mukherjee. Your lordship, kindly give me some time, my lord. I got the instruction, but report is not, yes, report is not prepared for myself.
Learned counsel for the respondent seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear on the 8th February.
Thank you.
Next.
Kabir. 82, my lord, I am appearing for the respondent number 7. Petitioner, 2 occasions they have taken adjournment, my lord. The matter was adjourned twice.
None appears for the petitioner, no accommodation is sought, dismissed for default. Go on. Next.
No. Number
83.
Petitioner, my lord. My lord, beseech your lordship to take 83, 84, and 86. These are 3 analogous matters, my lord. Lordship will remember these matters, my lord. I was the operator, and suddenly I was served with a termination notice that I have overloaded, and that was detected, my lord, at New Delhi. Now, my lord, there is a provision that in case of detection of third overloading, there is a possibility of termination, my lord. So they have terminated me without giving me a notice. That is why I filed a first writ application, my lord. During the pendency of the first writ petition, my lord, they have considered my representation as an appeal, and they have rejected the appeal with a single liner that your appeal is rejected. This is for the second writ petition why I have filed. And third one, my lord, is I have challenged the tender, issuance of tender. Lordship was pleased to, the tender was initially cancelled and discharged from their end because they didn't get the reserve price, because the price was fixed at 43,000. I was operating at much higher rate, 54,000. Now, as they didn't obtain the desired price, my lord, they discharged the tender on their own. Lordship has recorded that aspect. Now, my lord, after discharging, they again issued fresh tender, which your lordship has stayed it till 22nd. Now, my lord, appellate authority's order is also stayed till disposal of the writ application. Yesterday, my lord, I received one instruction from my client, my lord. They have restored the operation, my lord. You should kindly have a look at.
My lord, last
Acha,
officer, my lord, please be instructed. No, I'm not page it. Instructed me to give them direction that no steps may be taken until the matter is heard on today. So I have given the instruction, and this is the outcome of such instruction.
So I'm grateful to my learned friend, my lord. He has at least advised his client, my lord.
I follow this.
Now, my lord, kindly see this second paragraph. Second paragraph, he says that you are requested to start your lease operation loading in the said 3.9 FSLR space of 12381 up with immediate. Yes. Now, my lord, kindly see the rate which I have quoted. That is 50.
No. Restoration means, my lord, he was terminated from operating the lease agreement, my lord.
Restored that.
Yes.
But why this language in disposal?
Just now I have seen.
My lord, disposes of, I will be again terminated. I should feel secured, my lord, at least, because prima facie nothing has been found out against me.
No, that is not the correct. That is not a correct.
And then there should be a direction for affidavits, my lord. Let them act in terms of it. Because they have. Because
to continue because otherwise it will be.
Yes, my lord, they have stated so.
First writ petition is already, my lord, infructuous.
They have stated
First
so
writ
till
petition is
disposal.
already infructuous.
Line.
I am in respect of the first writ petition. So I think, my lord, that writ petition is already infructuous.
Probably, my lord, that was challenged, my lord, challenging the termination notice and also the issuance of the first tender.
And thereafter, appellate authority passed the order that is under challenge.
Excellent. Termination notice, my lord, culminated in appellate authority's letter. Lordship has stated that till disposal of the writ petition. That is the second writ petition.
জানতেন
সকালবেলা দেখি
আমি তো এই প্রথম
This was the order.
আগের দিন মামলা ধরেছিল ওই মামলাটা, তখন জজ সাহেব বললেন যে একটু বলে দিও, আপনি একটু বলে দেবেন।
Lord, all the 3 order copies are, my lord, I'm handing over.
First petition challenges the letter of termination.
Termination. And also the issuance of the tender. First tender, my lord, which they themselves discharged. Second was the appellate authority's letter. Lordship has stated that because it was not a speaking or reasons, only one liner. And the third writ petition is, my lord, the challenge was thrown to the subsequent tender. Lordship has stated that also. And Lordship will find from the letter which I have handed over at present, my lord, I was paying 53,666 and their reserve price was 42,000. And I still, none can have matched with my rate. And they were earning revenue from me. And good sense has prevailed. Now they have restored it, my lord. And they have not preferred any appeal against these orders.
So shall I record your undertaking that this part is mistakenly recorded here?
No, my lord, that was not the object of issuance of this order, my lord. This order, my lord, can you see the second paragraph? You are requested to start your lease operation loading in the said 3.9 ton FSLR 1 space of 12381 up with immediate effect till disposal of the writ application. Writ application. So actually directed to allow them to resume their duty.
Till disposal of the writ application.
Obviously, my lord's order is stay of the operation of the order. My lord's order is stay of the operation of the order. Order of termination and subsequent order of the appellate authority has been stayed by my lord.
My lord, in that case, my lord,
in the disposal of the writ application. Actually, until and disposal writ application stay means, my lord.
Yes.
First
Lordship,
writ application was.
This is the order.
Number
is 28543 of 2023. Yes, this is the order, my lord.
In 28543, you challenged the auction.
Second one. No, not withdrawn, my lord. Lordship has stayed the tender opening. Opening of the tender was stayed till the adjourned date, my lord. Now, my lord, kindly said, if they are allowing me to operate the parcel space, then in that case, my lord, can set aside the appellate authority's order and also the tender, then I can feel secure. Or else, my lord, dispose it off, then lordship, at any time, again, they will discontinue my service.
Not really a
Order of compliance.
no, not that. This is not really an order to restart your lease. This is only in compliance with the court's order. The court says till disposal of the writ petition, it is stayed. But when it's
No, lordship, they have said to ask me to deposit the advance freight charge for availing the parcel space.
Obviously, my lord. If they continue to operate their lease agreement, my lord, they have to pay.
I will pay. They have said I will pay. But if lordship I pay and subsequently
without payment, he cannot be allowed to continue.
Subsequently, যদি কোনো offense record করে তাহলে নিশ্চয়ই steps নেবে।
Infructuous to some extent because appellate authority's order has been passed, that has been stayed. It has merged, termination order has merged with the appellate authority's order.
So let this be disposed of first.
Let first
Not serve any purpose.
it will not serve any purpose.
We dispose of it.
First. 83.
তোমরা মারপিট করো।
করুন না।
Order impugn.
Appellate authority orderটা কোথায়? Appellate details orderটা কোথায়? Appellate details orderটা কোথায়?
And an order
Keeping
passed
orderটা।
by the appellate authority. The present application has become infructuous. The petition disposed of accordingly. Urgent certified. Now we come to 684.
Lordship, 684 and 686, the challenge still survives. Because I have challenged the appellate authority's order.
684.
My lord, clarify. My lord, there are three writ applications. First one, the termination of the contract.
for the first one. That
Second one, after the termination of contract, they prefer an appeal.
এটা নয়
An appellate order was the upholding the order of the termination order. That has already been challenged under WPA number 227787. I will not touch it. Got it.
You wanted to file take instructions and file a report, I think, in this matter, the second matter.
Matter is involved absolutely on the basis of the contractual agreement, terms and condition of the contractual agreement. The only thing is this, there is no dispute, my lord. There is no dispute that he was found during the special investigation, he was found uploaded more weight than that of the minimum requirements, my lord, in violation of the terms and condition. My lord, just this termination order was issued. The termination order was issued, my lord, upon considering of this. এটা আজকে যে আমাকে দিল একটা যে টার্মিনেশনটা দিল্লি থেকে যে চিঠিটা পাঠালো, মানে মেয়াই লিভ ম্যান কোথায় গেল, মাই তো ছিল এখানে। যাও তুমি চলে যাও।
My lord, so far as my learned friend's contention is concerned, my lord, their action is against the rules and regulations of the FM circular.
I'm coming to the
and
point. I am just placing the factual matrix of the case, my lord. This is the letter received from that Delhi authority, my lord. Kindly see. ওই দেখে এটা। বলাই যাচ্ছে। বলে নি একটু খাই যাবে।
The appeal was heard after giving an opportunity.
No. Neither the termination letter was issued with a notice, my lord, nor the appellate authority's order was issued without giving an opportunity. And it is under the FM circular, there is a provision to give me a notice before they want to terminate.
Have you complied with such?
No, there is a conflict, my lord. The terms and condition attached with the agreement, my lord, kindly come to
28.2 is the provision, page 42.
Come to page 52, my lord.
52.
52, my lord.
Yes.
Termination of the contract. This is a part of the agreement. Okay? Agreement executed by and between the railway authority and the writ petitioner. Railway shall reserve the right to terminate the contract as a punitive measure without any notice at any time in case of violation of the terms and conditions of the contract or due to any other serious misconduct, including but not limited to violation of the Railway Act, commissioning an unlawful act which is not in line with a good industry practice. So the factual matrix is this, my lord.
Kindly see 17.2, my lord.
I'm bullshit.
It's so they have to give me notice.
Now, why this was invoked, my lord? Come to page 70, the impugned order of termination.
17 months.
70. Is it application number?
Yes.
This is the order of termination. My lord, kindly see the last paragraph of the ordering portion. No, an agreement for leasing of 3.9 ton FSLR case number 123 up for the contractual period 2723 to 1735 at the party for 060 days in a week with phase 1 was executed between the leaseholder versus Ma Natula Cargo Service Limited, Lesser Railway Administration. The subject concern is awarded through a e-auction floated by this division. Thereafter, based on the letter number Deputy CBO TNR latest number so-and-so, so-and-so, which I have handed over just now, my lord. Which I have just now handed over. That what that letter contains. Letter contains that during a preventive check conducted by the NR Vigilance Department on 18th August 2023, overloading was detected as detailed below. In view of above, it is requested to take suitable action. And lastly, for such quantum of overloading is deliberate act of violation of terms and conditions of the agreement, and such quantum of overloading in passenger carrying trains is not only, this is the ground we have taken, my lord. This is the we have shown such quantum of overloading in passenger carrying trains is not only a threat and damage to railway rolling stock track, but also put a question mark on safety and security of the traveling of the passengers.
This is with regard to termination of the contract.
This is the
Against that order, the petitioner preferred an appeal.
Appeal.
Before the authority.
My lord.
So is there any provision for hearing out the appeal also without hearing the petitioner?
No. Is there any provision for hearing?
Appeal filed by the petitioners? the
Yes,
petition
yes,
has to be
yes,
heard?
yes, yes.
So why don't you reconsider the appeal upon hearing the petitioner?
When Malachi direct, we shall consider the appeal. We shall consider appeal upon giving opportunity of being heard to the parties.
Please place your case before the authority.
No, my lord,
That will cut short the matter.
to cut short the matter, my lord, only one thing I want to say is this. So far as their punitive measure is concerned, my lord, I have not overloaded in the Eastern Railway. That is not their concern. Now the situation is this. The provision is clear that in case of 3 overloading, they are empowered to terminate 3. Now they have flouted that rule. They have also flouted their own commercial manual.
The first overloading detected, if so.
Yes, because it is the responsibility of the Eastern Railway to verify and check and remeasure. It's not that I say that I have underloaded. They have to re-verify it from the wordings of the manual itself. It's
You were not given an opportunity before the authority. Place entire case before the authority.
My lord.
All that you are saying here, let the authority decide. Let the
Right.
appeal be heard in your presence upon.
After giving opportunity of being heard and
then
past the reason.
they are not to continue in terms of this till disposal of the.
My lord. My lord.
now, my lord, in that case, the tender has been, I have challenged the tender also. A tender
till the disposal.
Now, my lord, now, my lord, kindly visualize one aspect, my lord. I say the rules were not followed here because I was not given an opportunity of hearing. No notice was served. There is a violation of notice of appeal and also the termination. Lordship has seen 28 point.
Clause of this violation clause is there.
Yes, but kindly see 28.2 is very clear. 28.2 says, Lordship, kindly come for once for my satisfaction, Lordship.
Page 1.
Page 42. Yes, 28.2, my lord. Shall have the right to terminate the contract agreement for any reason.
18.1 is an exception.
My lord.
Then when 18. Same.
Same circular
My lord.
That is circular is a standard conditions of.
has been carved out.
Now, my lord, another provision 17.2, kindly see. Page 45. Oh, page 45.
No, 45.
No. 52. 52. Yes, 52. 52, Lordship, kindly see 17.2. My learned friend has taken your Lordship to 18.1. Guys, 72 is also says the same thing. Railway shall have the right to terminate the contract agreement without any financial repercussion on either sides for any reason whatsoever after serving 1 month's notice to the contractor. So, for any reason also includes the punitive reasons. They are contradictory. My contention is this. I have not flouted any rules. The overloading was detected by a different railway authority, not the tender issuing authority. That is the Eastern.
Violation of terms and conditions.
Now, that violation can be, Lordship, given a go by because of the reason there is not a single overloading thereafter. I was allowed to operate after this incident for continuous 3 months without there being any disturbance from railway side. Now, all on a sudden, this notice of termination was handed over to me. The only aspect is the overloading which was detected by another railway. I load from here, Eastern Railway. Eastern Railway has a mechanism to verify my claim is.
This is not correct.
Then, if my learned friend is saying
Well,
false.
he has to give declaration.
No.
He has to give declaration.
Kindly see.
There is no mechanism.
My learned
Then
friend.
every train has to wait for more than 3 hours.
Kindly come
for
to
weight
page.
measuring of the goods.
No. Just by saying false, it will not say.
You are just spending time while place these facts before the.
Kindly come to once for 74, my lord. I will not place anything after that. What my learned friend is saying is not correct. Probably 74 says otherwise.
Responsibility.
75. Next page. B. Top left hand B. Railway receipts. The receipts foils should not be granted till goods tendered for dispatch have been correctly examined and weighed.
Railway is responsible.
No.
And now can they say, my lord, that I have overloaded?
59, kind of company is 59,
No,
page
no.
59.
I have not read,
Page
no,
59.
I have not read the entire paragraph. When the senders are required to load their consignments, a railway receipt should not be granted until the loading has been completed to the satisfaction of the railway. And also the circular says all the parcel spaces have to be weighed at originating station.
Page 59, 9.7.
And there is also a provision.
Page 15.
After that, it's a
If,
reciprocal.
my lord, if the weight has to be taken,
I am only citing the rules.
then each train has to
That is
stop
their
in the
problem.
station for 3 hours.
Responsibility, sir.
Yes,
The
yes,
railway
that is that.
issue a certificate to that extent.
Yes.
Yes,
That's
there is no mechanism
Yes,
to
let
weight
them
the,
produce a
weight the missile. The what is weight? The rule 59, kindly come to page 59. It will be responsibility of the contractor to ensure that the total weight of consignments loaded in the parcel space is not beyond the permissible carrying capacity of that vehicle unit leased out to him between any leg of its journey.
Vis-a-vis rule B,
That is the problem.
both the parties have responsibility.
So let them
Look,
decide.
whatever I say-
Let this submission be made before the authority and decide.
Avoid responsibility. The railway also has an equal responsibility to issue a receipt.
Yes.
It is also his responsibility.
Ensure, but the railway will issue a receipt upon examination, physical verification.
It is, there is no such mechanism, man.
Lordship, may I?
There is a mechanism, no such.
Yes.
As such, this clause was
The manual.
incorporated. As such, this clause was incorporated.
Cannot avoid responsibility by saying that there is no mechanism.
There is no mechanism, my lord.
It's a dangerous situation then, my lord.
Page 59, my lord.
So the railway cannot charge the contractor on this.
Yes.
I come to page 59, my lord. It will be 9.7. It will be responsible of the contractor to ensure that.
Repeating, sir. You're reiterating.
69.
And also the FM circular says all the parcel space has to be weighed. They cannot transport any overloaded parcel van that compromises with the safety of the passengers. I will place.
Another part.
I want to say, my lord, that lordship will sending me to the appellate authority. But appellate authority, my lord, the terminating authority, I lose that forum because terminating authority has against me.
And they, even if they say it's violation of rules, fine, let us take that.
Now, my lord, if the appellate authority again takes a decision against me,
Place all your cards before them. And make you some, I'll give you, you'll be granted an opportunity.
then, my lord, in that case, I should be allowed to operate in terms of this.
Yes.
And also, my lord, because lordship, the practical difficulty is this, my lord, they all are not stopped my operation. No, that is after 2 months, 3 months, my lord. They have understand their difficult wrongdoings, or else they would have preferred an appeal.
They are only complying with the order of the court. Since the order has been stayed till disposal of the requisition, they have said, fine, you continue till disposal of the court. In compliance with.
And also, lordship will appreciate one aspect.
Your problem at all, sir. Don't be under the.
Now, they will never understand, my lord.
Don't be under any misconception that they have understood their mistake or whatever.
Now, my lord, only the thing is this, practical difficulty is this. After I was terminated, there is not a single allegation of overloading against me. Lordship, can appreciate this aspect. And also, they are asking me to operate right now. I will do so. Now, in the meantime, I have to accumulate business. Now, all on a sudden, they again reject my appeal. They stops. Then again, my lord, the same.
Wait till the rejection. You are on apprehension. Place your cards before the court. All the surplus, whatever you have said.
Just
Convincing. So please,
page 62, kindly see. Just
authority will see.
loading and unloading will not be supervised by railway staff.
Oh,
is also there.
There are so many things.
At page 62, so many things are there. Let the appellate authority decide.
And if that be
Not be supervised. At the same time, the railways will issue a certificate saying that the weight is.
That is the problem.
And another railway will say, I have overloaded, and they will communicate to me, and they will not serve any notice, and they will simply terminate. Now, I am generating revenue for the railways, and this is how he is treating me.
The primary response of the petitioner is that the appellate authority has rejected the referred by him without granting an opportunity of hearing to the petitioner and also without recording of a reason to order therefore. But it appears that the said fact was the said fact has been recorded by the school in its order passed on 19th December 2023. Stop. The order included the order included dated 8th December 2023 has been stayed till disposal of the petition. Correct. The counsel for the petitioner produces an order passed by the assistant commercial manager /HG, for senior divisional commercial manager, Mr. Davies /Howrah on 23rd January 2024, requesting the petitioner to start these operation /loading in the 3.9 ton FSLR -Roman 1 space of 12381 R 12381 with immediate effect till disposal of the requisition. The said order appears to have been passed in compliance with the order of state imposed by this court on 19th December 2023. Stop. Paragraph. Since it appears that the appeal has been disposed of without granting an opportunity of hearing to the petition and also without recording the reasons for rejection of the who is the appellate authority?
Divisional Railway Manager.
Or the senior divisional commercial?
No, the Senior Division Commercial is the terminating authority.
The divisional railway manager?
Divisional Railway Manager.
The fourth
DRM, my lord, DRM. DRM to? Yes.
fourth respondent.
Yes. May I see, my lord? The Divisional Railway Manager, Appellate Authority. Yes, my lord, fourth respondent. Divisional Railway Manager. Fourth respondent, my lord.
কথা দিয়েছি আমি বলবো কালকে যদি অর্ডার করি এক্ষুনি অর্ডার পাচ্ছি বাচ্চা ছেলে আমার আর্নিংটা আসছে এগুলো এগুলো যদি আর্নিং যতগুলো প্যাসেঞ্জার ট্রেন আছে পেছনে লাগে আমি থেকে যে টাকাটা আছে সেটাতেই ট্রেনটা
The order passed in the appeal, which was communicated to the petitioner by a letter issued on 8th December 2023, is set aside paragraph the appellate authority being the third respondent.
Fourth respondent, my lord. Divisional Railway Manager.
Is directed to
opportunity of
revisit the issue. Pass reason and speak in order. To all concerned, including the petitioner, in accordance with law. Within 1 month?
Yes.
Within 1 month from the date of publication. Paragraph. The
upon opportunity being hard.
petitioner shall continue with the lease operation / loading as indicated in the letter dated 23rd January 2024 till disposal of the appeal.
Till this was only 1 week thereafter, my lord. The event, if it is
1 week thereafter.
Till 1 week after
Yeah.
disposal of the appeal.
regarding the tender, my lord, lordship has.
These are all separate issues.
টেন্ডার আমরা আছি আলাদা অর্ডার পাস করবে বিল পাবো
এটা এই ব্যাপারে রিটার্নটা স্টে করবে
আর আলাদা অর্ডার পাস করে বিল পাবো
686.
686.
686
order 5 foot. Order 8.
আলাদা আর কেস দিয়ে দাও প্রশ্ন এটা তো আছে হ্যাঁ আমি দুটো দিয়ে আমি অর্ডার নেবে তো আলাদা অর্ডার নিন তাহলে আমাদের বিল হবে না কি
Passed in WPA 7787 of 2023, directing reconsideration of the appeal petitioner. E-auction with regard to serial number 18 of the auction
Catalog.
dated 14th December 2022. We stay till 1 week after disposal of it. This matter is also getting disposed. The e-auction will be subject to result of the appeal that has to be taken and disposed. Shall be subject to the decision of the appeal tribunal.
Actually, only the population of hearing my lord, the petitioner or his legal representative. Well, that may be given.
Slash his legal representative.
আগের মামলা আগের অর্ডার
Slash his legal
Great.
Lordship, 482 Lordship, after I'm coming from another court in just matter call. Just 482 Lordship, kind. 682 Lordship. I am for the petition, Lordship, I am left the another court. Lordship, dismiss for default, Lordship.
Dismiss for default, I appear for.
Not today, Lordship, not today.
ওই বলো so I'll party
685.
685 minute. My prayer is very innocuous minute today
Statement.
because where no decision has yet been taken. But we have made several. We are doing that works minute relating to advertising on the basis of the work orders issued by the government. Minute.
अरे फाइल तो
On the basis of the work orders minute issued by the government. Now, minute, we have made representation. Minute, the claims yet to be settled. Minute. But they have not said that this your quality is not fine, so we cannot pay this money. We have raised bill, they have not done, paid us. And we have made representation. They have replied at page 214 and 15. This is the reply of the state government.
Is the state the only party?
Yes, yes, they are the only respondent, answering respondent.
But the matter pertains to group 9, my lord, because how the group 7 matter has come, I do not know.
No,
The
the advertising, telecommunication.
Yes, my lord. Some amount
That's why
is due.
Now, this is the representative. I believe that nobody will be prejudiced.
For advertisement, my lord.
That's why they are the answering respondent.
This court deal with this?
Because they are the authority who has issued the order based on which we have done the work. Now we have raised
Does it have
advertising, telecommunication.
advertising is not telecommunications?
This is medium. Medium. My prayer is kindly, if you kindly see 215.
Bench.
Kindly see 215 once. I believe nobody will object. They says these are to be considered.
Of course, your prayer is, if I do not have determination, can I deal with it?
No. Now, I believe telecommunications, media is falls within this. I believe there is no dispute because Broadcasting Corporation of India, that is within the jurisdiction of your lordship. Department of Information and Culture, your lordship determination. No, no. Aha, media.
Where is letter dated? Let me see what you are asking for.
Kindly see 215
How is it?
214, 215
Where is the application?
My application is at page
Sir, the forwarding letters.
no
114 and 15 are forwarding.
is foreign letter. My letter is at page 212.
An application is being forwarded. Where is that?
My application, yes, 212. Several communication 211 onwards. 12 rather than 211. To the Director of Information and Culture Affairs.
I don't think this can be dealt with by this.
Kindly see who is issuing the orders.
It's like, a murder taking place on a land and you see it is land matter. It's like this.
No, not like that. Okay. Page 32. 32.
Right, sir. Please hold the.
Department of Information and Cultural Affairs, page 32, they are issuing the work orders. But I don't think the residuary is the residue.
You are asking for your dues from the authority.
Yes, on the basis of the work orders, that really. If
Group 7.
if any tender is issued,
Your apprehension.
if Panchayat authority issues a work order, on the basis of a tender, if I have to go to the residuary bench, if it is matter relates to Panchayat department, Panchayat court having determination of Panchayat and pass order always. Residue is always residue.
We do not consider residue as much. If you like to release it, then we are not claiming money right now.
The matter be released due to lack of possession. Next, I'm sorry. Next.
In this matter, I am appearing on behalf of the petitioner.
87.
So here is this, my lord. We are holding a permanent stage carriage permit on the route Malo Bardhaman to Asansol. My lord, that permit was valid till 18 May 2025 and was to time to the condition of permit that is done. But during the validity of permit, I made an application, page number 29. Page number 29.
Yes.
An application for curtailment or diversion of the road. Serial number 4. Because my lord, a application for variation curtailment, it is still a new grant of permit. So my lord, we have made an application in prescribed form with the requisite phase. Original permit Bardhaman to Asansol via Sajan Shah and curtailment and diversion from Rani side to GT Road and Kalikwadi, and after curtailment on variation, new route is my lord Bardhaman to Asansol. Bardhaman to Asansol and via Panaghar City Center under Rani side GT Road Kalikwadi. And that is the application with the requisite phase. With the requisite phase, and with the timetable and requisite phase, my lord. Page number 31. Page number 31 requisite phase. Along with my timetable, route map, and also other documents have annexed in this application. Now, after receive that, inquiry report also submitted, page number 34. The motor vehicle inspector report was also submitted from the, because route is covered by two regions, Purba Bardhaman and Paschim Bardhaman. A report also submitted from the end of the Purba Bardhaman. And next page, page number 35. Because 103 is required to be compliant. For this reason, my lord, Secretary at the Paschim Bardhaman, page number 35, filed memo dated 27 March 2023, requested Secretary at the Paschim Medinapur requested the Secretary at the Purba Bardhaman. My lord, in the first paragraph, Lord, existing route has been mentioned. Second paragraph is very vital. In reference to the above, this is to inform you that the inquiry report and no objection certificate under Rule 103 of West Bengal Motor Routes 99 for stage carriage permit in favor of Mr. Devi Paru Transport, Chotanipur, Ambanga Northern Colony, Tripoli, Bardhaman, is required from you, and copy of application, route map, and proposed and also proposal timetable, proposed timetable are attached with here. As the diversion route is under your jurisdiction, it will better if the inquiry report is sent at the early date and NOC because according to Rule 100, if an inquiry is covered by two regions, both the regions will sit together to take decision. For this reason, NOC is required. Well, after this, this memo was issued by the Secretary at the Paschim Bardhaman 27th March 2023. Secretary at the Purba Bardhaman, after silence and no response was given. So, my lord, I made a representation, page number 36.
Yes.
Page number 36. On my lord, at the bottom left side, receipt copy on 6th December 2023, requesting the my lord Secretary at the Paschim Bardhaman, Purba Bardhaman, to take a decision because it is the duty of the Paschim Bardhaman, Purba Bardhaman, to inform whether why there is delay of response because 103 compliance is required. So kindly direct my response number 7 to give the reply of this memo, and after that,
Paschim Bardhaman has to reply. Why?
yes, Paschim Bardhaman will give up, not Purba.
No. Why it should be related to the Purba Bardhaman?
Requested to consider.
No,
matter is pending.
you have to make an.
What am I making? So kindly direct the Paschim Bardhaman. Yes, Paschim Bardhaman. I don't know.
But this is addressed to the Purba Bardhaman authority.
Purba Bardhaman, why? Because I apply for diversion. That application pending.
চুপ করবে নাকি?
না আমি
আর অনেক মামলা just time 11
আমার তো এক মিনিট
may I submit one thing? Lordship, can you turn to page 35? 35. Lordship, can you direct the respond number 7
ওইটাই তো আমি বলছিলাম
to Paschim Bhatta, Secretary Paschim Bhatta, to take a decision within previous certain time and communicate the same to the Purva.
হ্যাঁ ঠিক আছে
তুমি তো একটা রিপ্রেজেন্টেশন করেছো পূর্ব বর্ধমান। পূর্ব বর্ধমান অলরেডি ডান ইস
আমি 7 এর উপর অর্ডার করতে চাইছিলাম
ওকে ওকে
Representation has to be finally disposed of by Purva Bhatta
yes
after NOC.
yes
after NOC.
This is my
Will this come within 2 weeks and another 2 weeks?
yes I because the delegation power has been to the secretary so board meeting is not necessary
Every day was this. The
petition দিয়ে দেয় আমাদের কি অ্যাডভাইস দেয়
petitioners. They issued permanent stage category in the route from Bardhaman to Asansol, which is valid till 18th May 2025. Stop. The petitioners applied for diversion of.
curtailment my lord page number
You've asked for curtailment also.
yes curtailment diversion board because fees was accept page number
Of the
31 fees accept for curtailment page number 31
Submitted an application to that effect along with requisite fees.
31 fees application for curtailment fees middle portion
And other relevant documents. The Secretary, Regional Transport Office, Purva Bardhaman, via letter issued on 27th March 2023, requested the Secretary, Regional Transport Office, Paschim Bardhaman,
yes
to send the inquiry report as well as no objection certificate in this regard, since the diverted route fell within the jurisdiction of the latter. Paschim Bardhaman.
yes
No response being received by the Secretary, RTA, Paschim Bardhaman, the petitioner submitted a representation before the Secretary, Regional Transport Authority, Purva Bardhaman on 6th December 2023. Seeking necessary approval.
necessary NOC madam
NOC no objection certificate under rule 103 of the West Bengal Motor Rules 19.
Approval / NOC. Because final approval has to be given by Purva
yeah
Bardhaman.
my
The petitioners seek consideration of their representation at the earliest. Paragraph upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since inquiry report as well as no objection certificate is yet to be received from the Secretary RTA Paschim Bardhaman, the said secretary, SAID, comma, being the
This was 7. No, no. Delegation for the watch.
Portion is 5.
Postum is secretary is the 7. 5 is board.
37. Being the seventh respondent here, comma, be directed to
Secretary delegation for the watch. কোডটা তো পুরো বর্তমান
furnish the inquiry report as well as no objection certificate before the secretary, comma, RTA Purbo Bardhaman, comma, that is the
being respondent of
fourth respondent hearing within 2 weeks from the date of communication of this order. So, upon receipt of such inquiry report and NOC, comma, the fourth respondent is directed to consider and dispose of the application as well as representation submitted by the petitioner. Hearing is
hearing.
upon petitioner within another 2 weeks.
Which my hearing is
4 weeks. Within 4 weeks therefrom,
mine.
upon according to hearing to all concerned against the petitioner, comma, in accordance with law. So, the decision taken by the authority shall be communicated to the petitioner within a year thereafter. Next.
This matter, my lord, I am appearing for the petitioner, my lord. This is a case, my lord, for non-issuing the permit of the modification route, my lord, after being deposited the requisite fees as per leave granted by the Honorable High Court, my lord. Your lordship kindly come up, my lord, page 17. Earlier occasion, petitioner come before this Honorable Court, my lord. The Honorable Court dismissed the writ application, my lord, as the petitioner did not make an application with proper form and with requisite fees, my lord. Then petitioner was given liberty to make an application with proper form and requisite fees, my lord. Now, my lord, the petitioner given requisite fees, my lord. Deposited page 19, my lord. But till date, my lord, no decision has been taken, my lord.
Where is the application?
Page 19, my lord.
That is the fees.
Yes, my lord. Then
There a fresh application because the earlier application.
next page, my lord. Next page 21, 20, 22, my lord. This is the proper form, my lord. Yes, my lord.
Let it be considered.
Yes.
Pursuant to liberty granted by a coordinate bench of this court by an order passed on 23rd February 2022 in WPA 2220 of 2022, comma, the petitioner applied for extension/modification of the route in respect of which he was granted permanent stage carriage.
Yes, my lord. Yes, my lord.
Permanent stage carriage permit. Permits. Now, the petitioner has deposited requisite fees for the same. The application is yet to be considered. Stop the petitioner case for a direction of the consider the application. Paragraph Learned Counsel for the respondents submits that Secretary.
No, well, RTA board. It new.
The second respondent be directed to consider the application in accordance with the application. Paragraph in view of the above, the petition is disposed of directed to the second respondent to consider and dispose of the application filed by the petitioner within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing, observe the petitioner comment and analysis of paragraph, the decision taken by the authority shall be communicated to the petitioner thereof disposed of. Next.
May I please, Your Lordship, I'm appearing on behalf of the petitioner. This is the affidavit service. This is a very short matter wherein on 12th May 2023.
Sir, the fourth respondent.
Yes, my lord. Yes, my lord, I've given the affidavit service.
The Past Owners Association.
Private response. This is the Purulia Bus Owners Association, my lord. Delivered.
Yes,
Lord, on 12th May 2023, I have applied for a grant of permit in the route Lalpur to Ropo via Chatumandor, Keshargarh, Bhangramore, Purulia, Chas Road, Jaipur, and Pandang before the RTA Purulia, Regional Transport Authority Purulia. Subsequently, upon my application for grant of permit, a meeting was called on 6th October 2023. Wherein, after perusing all the documents of my application, the authority has pleased to grant me the permit and requested me to further submit few documents, which I have submitted on 9th October, 3 days after that meeting, declaring the affidavit that I am running, that the vehicle is idle, and all the registration documents and all. I have submitted all those documents on 9th October. That is starting from page 21, my lord, and it's a P1, along with one representation. Subsequently, on the 4th week of December, on the website, the resolution of the meeting was published, wherein, kindly come to page number 35, serial number 13. Atish Gupta is the petitioner, my lord. Yes, my lord. Application for new permit from Lalpur to Ropo via such and such for vehicle number WB 55B 1712 BS4, which is already within the norms of BS norms. As the route is very long from Keshargarh to Ropo, portion is allowed subject to submission of class 3 timetable and surrender of previous permits like STA permit. They have rejected hearing, stating that the route is very long.
It's not really rejected.
As the route is very long from Keshargarh to Ropo, portion is allowed subject to Keshargarh. My route is from Lalpur to Ropo. They've allowed on portion only because they state that the route is very long. Subsequently, in the same meeting, serial number 6 and 7 at the top, page number 35. These two are also routes of different operators, application of different operators. Routes are different, maybe. My lord, one second, my lord. Kindly come to page number 37. That is Boro Bazar to Bandwan. The total distance is 111 kilometers, which has already been.
What distance?
No, my distance is 92 kilometers.
Yes, Boro Bazar to Bandwan, who has been granted?
Boro Bazar to Bandwan, my lord. Item number 7, serial number 7. Application for new permit from Boro Bazar to Bandwan via such and such. All the vias are there in the map. Allowed. Subject to class 3 timetable. Here, no mention of the long route is there. Next page, page number 38, Kashipur to Purulia via Sindhi Ropo. This 150 kilometers, my lord. That is also been allowed. Point number, serial number 6. Wherein, page number 31,
Yes.
In page number 31, Lalpur to Ropo, all the vias are there. My kilometer is 92 kilometer. There's no justified reason that my route is my reason in allowing my route partially. There is no any proper reason.
Let the state respond to this. Yes, Mr. Bindra.
And this is all being done in connivance with the respondent of the private, the same bus owners association. They're involving the bus association in these matters, despite court's order.
Then per distance, how will this come in? I think
All the vias are mentioned therein.
that is better, man. I shall take.
111 kilometers.
All the vias are mentioned
What
there.
was at page 37?
Page 37,
111
what is it?
kilometers, the total trip is 3 hours and 21 minutes. And page 31 says
31.
it's 3 hours and 13 minutes, 92 kilometers. So what is the reason for this?
I shall ascertain before.
None appears for the private respondent as results. The petitioner applied for permanent stage carriage permit in the route Lalpur to Ropo, RPO.
Moreover, my lord, in this route, in my route, which I have applied, there are many regions which are in need of transport service. Also, there are averments in my petition. There are very remote villages which require this kind of transport service.
Which was taken up for consideration by the RTA board, in its board meeting held on 6th October 2023. So, the RTA board allowed the application of the petitioner for the route Eshwargarh to Ropo, subject to submission of class-free timetable and surrender of previous permit / STA permit for the mentioned bus, if any, as the entire route from Lalpur to Ropo was very learned counsel for the
Though all the relevant documents is already submitted, my lord, on 9th December.
learned counsel for the petitioner submits that relevant documents in support of his claim has already been submitted to the committee. So, the authority has granted permit in the route Barabazar to 11 BUN, which comprises 111 kilometers. Stop. The route of the petitioner from Lalpur to Ropo. Lalpur to Ropo comprises 92 kilometers. Counsel for the respondents seeks to take instructions in this regard. paragraph, let the matter appear under the same. 16th February.
And meanwhile, no action should be taken against this route. In the already at the Keshwar to Ropa, if anyone applies, my lord, no one.
Can apply, that is not.
What, you will not be prejudiced by any action. Come back. It's a short. Next.
Well, in this matter, I'm appearing on behalf of the petitioner. Well, I'm filing evidence of opposition. Evidence service. My lord, the identical case, my lord, is regarding e-rickshaw. So, my lord, I'm placing one judgment because I'm the manufacturer and also, my lord, obtain the prototype certificate under Rule 126 of the Central Rules 99. And I have annexed other documents also. My latest judgment, my lord, that is also included in the FMS matter. Appeal matter also consider that. And my lord, I have annexed, my lord, 13 January 2022 notice and also 13th July and 13 July page number 153, 85, 13 January, page number 85, and my lord, page number 153, 13 July.
The same order will be passed?
Yes, sir.
যেখানে added e-rickshaw. The director, transport director.
Yes, this one number 3.
Here also it is 3.
Yes, sir. He made this one 3 director.
Affidavit of service. Next.
Well, next matter also identical same. Affidavit service matter.
Next matter also you are appearing. Thank you all.
No, 13 January notice, page number 93. And my lord, 13 July notice, notice, my lord, page number 161. 93 and 161, page number.
Same order.
Same.
Next.
Actually, I'm for the petitioner. Same. E-rickshaw.
92.
Affidavit of service.
Affidavit of service.
I have filed, Lordship. I have annexed, Lordship, kindly come page 166. Order passed by your Lordship earlier. I have annexed.
It's the same order.
Same order.
নামটা দেবেন স্যার নামটা দেবেন স্যার
অ্যাডভোকেট রেকর্ড তো আচ্ছা
Same order. Next.
93.
Deeply obliged. I am for the petition.
State.
I'm good. But the input order is at page 32.
Who is appearing for the state?
Well, I have served. Don't know who is the people. Private respondent will serve and state respondent will serve.
By email.
My lord?
By email. You served by email.
Served by email.
Yes, yes, ma'am. My mail through my ST Bihar and as well as my private respondent also.
Serve and come back, Mr. Sharma.
Government to नहीं तुम्हारे को नहीं तो GP I have some GP land is government paid also that is nobody is appearing.
What about Bihar?
मतलब Bihar I have some to मतलब speed post मतलब email that I can do. But land advocate for the state of West Bengal is not appearing.
That I can request Mr. Devra to appear. That will not be an issue. Or West Bengal, I can request Mr. Devra. I can request Mr. Devra.
না পাখি তুমি এত তুমি appear করছো তো আচ্ছা করে দিদি
Please serve Bihar and come back. I'll have asked Mr. Devra to.
I should do it, man.
Since service upon respondent numbers 4, 5 and 6 is not complete, the matter stand over 3. February.
My lord.
Size. 701.
ঠিক আছে
Three thirty. 330 matter 717. 717.
কি হলো
আমাদের 336 matter. Two matters are fixed at 330. Pass. Item 727.
717
717.
yes that's why 27 বলছো তো এখানে 27 ও করেছো
মাঝখানে কথা বলেছিস না
আমি তো বলি নামটা কি আমাদের
27 জন আসতে পারবো
please do.
I really don't know.
Well, first one I've almost concluded. I shall take 15 minutes for them to give their reply. In the second one, in the excellent, I had concluded, in fact, my rejoinder, but because in my rejoinder I cited two judgments for the basic proposition, they had said that they will want to make some submissions. But I do not know whether they would really, but the last occasion when I mentioned for extension of the interim order, they said I have nothing more to submit. So, do you have anything more to submit in excellent?
Excellent. That matter, my lord, I am led by an advocate general.
And in this
If he
matter,
comes-
this matter, you
No,
will.
This matter, I am.
So you will be making.
The other matters be released. The by brothers will.
Other
Other matter released. Other matter released. And 772.
তো মুখ খুঁজে পাচ্ছি না কেন? কেন এটা? Yes, madam. এই এখানেই গিয়েছিলাম ওকে মনে আছে ফ্ল্যাগ করে রাখা ছিল জাজমেন্ট গুলো আমার ওর কাছে আমি দেখাবো বলে। But here, my lordship may recall, we had shown that because of KMDA's I had in this was a case where the license deed did not provide for imposition of penalty. It was in my note, page 2, clause page 2, paragraph 3, the clause is set out. Now, there was no provision for imposition of penalty. May allow or not allow reasonable time to complete the building. Now, so that was my first point, that there was no provision for imposition of penalty, unlike the judgment which I shall show now is my lord's judgment as affirmed by the division bench. Now, the second point here in paragraph 4 of my note is they were not giving the lease because the process of acquisition was not completed. And the KMC was not accepting the sanction plan because on the basis of license deed alone. KMDA wrote to the KMC only on 14th of July 2010 to accept our plan and similarly placed persons' plans for consideration, irrespective of, because even though they are the recorded owners. And immediately thereafter, KMC allowed us. And 14th July 2010, we gave the sanction plan for sanctioning. And within 6 months thereafter, we could commence construction. So the inability to commence construction was because of a reason attributable to them. And the lease deed and the license deed did not permit them to hold back the execution of the lease. The license deed, the license deed had no connection with payment of pen. I mean, so far grant of lease is concerned, there was no there was no connection with any payment of penalty or interest or.
কনস্ট্রাকশন করার টাইম দেওয়া আছে কিন্তু না হলে কি হবে সেটা বলা
At least they could have bala. Because, or you may remember page 60, clause 6, Roman 4. Clause 6, Roman 4. Subclause 4.
Of the writ petition.
Of the writ petition. So they'll not grant, no non-execution of the lease deed was not. Yes. Page 460 of the writ petition.
Page?
64, page 60. Independent of all the clauses, 6 Roman 4, they were to execute the lease deed in my favor. Upon completion of process of acquisition of land, hereby licensed, and the transfer of the title to the said land in favor of the authority as KMD, authority shall grant and licensee shall accept a lease for 99 years, commencing from the day, month, and such term conditions. So there was no, I mean, it was not linked to anything. They were not being able to get the lease deed, as a result of which KMC was not, I mean, sorry, they were not being able to get the title, and as a result of which they were not in a position to give us the lease. And that was the cause of KMC not giving us the, I mean, no, not accepting the plans on the mere license. That was clarified, Lordship recall that page, at page 68, yes, 68 is when the KMDA ultimately wrote to KMC allowing mutation, because without mutation, Lordship, I had read out, I'm reading out one, this is very important. KMDA has been allotting bulk land to different institution business houses, one of them, on long-term lease. As per procedure, the residential plots, as per procedure, for residential plots, the registered lease deed is executed immediately. In the case of bulk land plots, in my case, KMDA executes an unregistered deed of license with the allottee. This is done to allow the allottee to proceed with his mutation building plan work from KMC and to ascertain this and to ascertain his seriousness. Only after the licensee has started actual construction work, lease deed is executed by KMDA. However, recently KMC has been disallowing mutation on such unregistered license deed. It may be appreciated that every allottee has a stipulated time limit within which he must start construction, failing which he is subjected to penal action and his allotments cancelled. With the mutation work being held up, the entire work of starting the project is hampered. In these circumstances, you are requested to kindly allow the mutation building plan. Now, Lordship will see first thing, this stand of theirs that they will not grant the lease deed till the construction is started is dehouse the agreement. Because the agreement makes clause 6.4 lease deed dependent upon their getting the land title transferred. So It is so they're acting dehors the contract, and they want the and they want the I mean and as a result of which KMC was not mutating. So after this clarification, KMC mutated, and within 6 months thereafter, leave aside 2 years, our building plan, we got the plan sanctioned and building started. So this was one aspect. Another aspect was the clause that is the 4.3, which is set out at page 2 and also in the lease deed, of course. That is in the license deed also, that this was that 2-year thing. That's also page 58. Further time as maybe as at the own cost of the license within 2 years or within such further time as the authority may add its option, allow in writing on sufficient and reasonable grounds to start construction. So there was no provision for imposition of penalty. And I have cited the judgments to show that the imposition of penalty cannot be unilaterally done by any authority, because it for the consequences of breach, one has to go to court, get the damages assessed. I cannot say, because I cannot assess my own damages and levy. So this is the second reason. Firstly, of course, that for your own wrong you can't take advantage. Secondly, there is no provision for payment of penalty. And in this connection, I had cited judgments which are at page 9, page 8 of my notes. Page 8 of my note, paragraph 20. A penalty can be only by statute. Page 8 of my note, paragraph 20. For a person or authority to claim penalty as a matter of right, the penalty should be payable under authority of statutory law. Or in other words, penalty simply by way of statutory provision. Policy is not statute. This is Bhagwati Steels. I had cited the judgment. Also, my lord, for this proposition that you cannot on your own assess the damages, that is page 7, Chief Justice Chagla's judgment from Iron and Hardware, and the Prince at paragraph 17 of my note, page 7, which principle has been thereafter affirmed in Kailash Nath Associates case, paragraph 18, and also our High Court Division Bench, MBL infrastructure. Yes, even if there was a provision, now those go one step further. Kailash Nath Associates and MBL. Even if there was a stipulation, that there will be penalty at so and so rate in case you cannot come. But that does not entitle them to get that penalty, because that has to be established that losses suffered. MBL infrastructure case was a case where there was a term in the tender that in case of misstatement, the earnest money will be forfeited. 51 crore was forfeited. The 50 lakhs were 1 crore. The petitioner came, admitted he had made a misstatement, but he said that you cannot forfeit without suffering any loss. The writ court did not allow. In the division, Justice Shunjib Banerjee, as lordship then was. So then he said, following Kailash Nath, just because there is a penalty provision, you have to, without establishing that the loss suffered, you cannot claim this. And Kailash Nath Associates in Delhi Development Authority, similarly, when an allotment was cancelled because of non-payment of the balance money by the allottee, the provision in the allotment letter that some amount will be forfeited or some amount withheld was held to be not enforceable just because it is there. But I don't have to put my case that high, because I'm saying that there's no provision for penalty. Now, and Bhagwati Steel Mills case. Now, I had also shown in this context, in the context of KMDL license, Austin Distributors, page 6, paragraph 16, Austin Distributors in 2011. That judgment being there, law laid down by our High Court, that penalty cannot be levied by KMDA. They can't do it. And this is the same view, paragraph 15, KMDA versus Jalan Intercontinental is a division bench. Austin Distributed is a single bench, and KMDA versus Jalan Intercontinental is a division bench judgment, which says by policy decision, you cannot levy a penalty. But that's not law. So those are my two judgments. And next, my lord, was my submission on the basis of the page 9. I mean, Godavari, first question, Godavari. Paragraph 22. Levy of penalty on the basis of policy decision was not in accordance with law. It's a development of Bhagwati that law does. I have cited one Supreme Court judgment and H. Takar. And the other one, I think, our Calcutta High Court. Yes, Khaidan Steel was our High Court judgment. By whom? By Mrs. Mantha. And next is, they are asking for service tax on this police premium as an additional amount. There is no service tax payable, or as will be said, the latest SESTAT judgment. There is no service tax payable on lease premium. So that is 178. 178 of this compilation. That is a SESTAT judgment to show what is the. The first paragraph, this dispute of taxability under section 65 so and so arises from conducting agreement in which the appellant Star City executed with the conductor, Messrs. Movie Time, for granting conducting rights, which also included an option for purchase or lease the theatre belonging to him for lump sum consideration of 4 crores. It would appear that of this agreed sum, Messrs. Movie Time placed 250 rupees 2.5 crores as the interest-free security deposit, while on acceptance of request paid 43,250 per week as lease rental till the transfer for 99 years against lease rent of rupees 100 per annum for a consideration. The demand of rupees 21 lakhs as provider of renting an immovable renting of immovable property service between so and so date and so and so date was worked out on lease premium received and the lease receipts on which tax liability had not been charged, and on the finding that the transaction layered under misleading description for that very purpose. Now, Lordship will kindly see what is the kindly come to paragraph 3. It is the contention of the learned counsel for the transaction that the transaction is nothing but a sale, and hence beyond the pale of taxability. It is further submitted that taxability of rentals was under challenge, placing reliance on the decision of the tribunal that whether the service tax is payable only on the lease rent or also on one-time premium. This is a premium. In respect of lease rent, it was held that nothing is payable on premium. Ashwin, I'll see page 180, quotation, last 4 lines of the first para quotation. 180, first paragraph, last 4 lines within the quotation part. Therefore, the order in original confirming the service tax demand on the premium amount is not correct. And now finally, 184, paragraph 9. The decision on the taxability of premium laying down that. Now it is 10.1. I will just come to the last 4 lines of this quotation. Therefore, the order in original dated 30th April 2013, confirming the service tax demand on the premium amount is not correct, and to this extent, the service tax demand would not be sustainable. Was vehemently contested by the learned authorized representative in the course of argument in RICO and recorded thus by the tribunal, so and so. Now, paragraph 10. It's only on the actually paragraph 10. It cannot also but be noticed, page 185, last paragraph. It cannot be noticed, or it cannot also be noticed that Greater Noida, that in Greater Noida, there is no lack of clarity in the assertion of the tribunal that since the levy of service tax is on renting of immovable property, not on transfer of interest in property from lessor to lessee, service tax would be chargeable only on the rent, whether it is charged periodically or at a time in advance. Before going on to render the finding that in these appeals, the show cause notices issued by additional director so and so has been service tax has been demanded only in the lease rent and not on the premium amount, while the subsequent show cause issued 17th October 2012 issued by the Commissioner of Central Excise and Service Tax, Noida, the amount of premium has also been included in the lease rent for the purpose of charging of service tax, for which no valid reasons have been given. Therefore, the order in original dated 30th April 13 confirming the service tax demand on the premium amount is not correct, and to this extent, the service tax amount would not be sustainable. It appears that the principle of taxability that found favor was discarded in circumstances peculiar to that case, and absence of challenges in circumstances not to be presumed as conflict. We therefore do not find any contradiction between the two decisions. Accordingly, the lump sum payment becomes liable to the tax and the Finance Act. In addition to this periodic, for this reason we find no benefit. Now, Lordship, the next point which I had urged was the license deed here has since merged in the lease deed, and in the lease, page 126. 126 is the subsequent lease, which for executing which we had to pay the penalty, for which I am seeking refund, is to now 6A, to undertake. Now, this is the clause subsisting today. I will show judgment for the proposition that the license has merged the lease. To undertake, construct the building in conformity with such building rules for such purposes allotted for as may from time to time be framed by the authority or other authority prescribed in that behalf, and according to plans, designs, and sections sanctioned by the government or that authority within 24 months from the date of handing over of possession of the demised premises to the lessee, and or execution of the lease deed, whichever is later, and to complete the construction within 3 years from the date of possession of the demised land or such extended time as may be allowed by the authority. So 24 months from the date of handing over possession or lease, whichever is earlier. Whichever is later. So lease deed has come much later. Here, the only thing is that which is in there, which the other side is relied upon, is page 127 only at the bottom. Last two words of that page. Last two words. However, in those cases where the license deed has been executed, the commencement of construction to be done within 24 months from the date of execution of license deed and is to be completed within 36 months. Now, Lordship, so they are preserved, but the only difference I am showing here is, Lordship kindly sees 127, the third, fourth, fifth line. Such extension is allowed by authority, however, that on failure of the lessee to comply with such covenant, to commence and or complete construction of the said house or building within the time originally fixed, provided, however, that the authority may in its discretion on an application being made to it by the lessee and on payment of such fees or penalty, by whatever name called as may be fixed by the authority from time to time, grant to the lessee such extension. So the penalty fees has been expressly incorporated for the first part of the clause. That is, after within 24 months from the date of handing over of possession or lease, whichever is later. There's a provision for penalty. But those cases where possession was already given pursuant to the license deed, there is 128 at the bottom. There is no provision for imposition of penalty. And that is also the position in the license deed. I cannot be, so there is no provision for the imposition of penalty. And my lord, the earlier license deed has since merged in this lease. Just one judgment I will show. So one judgment. This 2014 to Calcutta High Court Notes 579. It's the context of arbitration. In an arbitration clause in the agreement for sale, after execution of conveyance, what is the fate of that? I'll showcase the first two paragraphs and then I'll go to the fifth paragraph. The petitioner seeks the reference of a dispute between the parties to arbitration on the strength of the arbitration clause contained in the agreement for sale. It is not in dispute that the agreement for sale has ultimately culminated in a deed of conveyance being executed by the petitioner in favor of the respondent on 8 December 2008. Now, Lordship, may I skip the next two paragraphs and come to the second last paragraph? However, in the present case, however, the facts in the present case do not involve the principle cited by the petitioner. In this case, the parties have executed a subsequent document wherein there is no arbitration clause. And the respondent suggests that since an agreement for sale is of limited import and that has culminated in a conveyance, the arbitration clause contained in the agreement for sale can no longer be cited for the purpose of adjudicating the disputes. Without going into the other issues that may be pending in the consumer forum action and in the civil suit instituted by the petitioner herein, pertaining to a subsequent document, it does not appear that upon the agreement for sale culminating into a deed of conveyance, the agreement clause contained in the agreement for sale survives in the absence of the deed of conveyance, specifically referring to the arbitration clause in the agreement for sale and keeping it alive. The matters covered by the agreement for sale are now part of the deed of conveyance, and the disputes pertaining to the transaction concluded by the deed of conveyance not governed by the arbitration clause. The culmination of an agreement for sale of an immovable property in a deed of conveyance executed for the transfer thereof cannot be equated with the expiry of a matrix agreement. I am not going into that. So এবারে দেখাবো এই আমার ফ্ল্যাগ থেকে তোমার জাজমেন্ট এটা তোমার জাজমেন্ট
এটা ছিল এইটা এটা হচ্ছে পেনাল্টি করা যাবে না
Yes, yes.
Putting up a factory within a particular time for the purpose.
কোন প্যারাগ্রাফটা বলেছিলাম প্যারাগ্রাফটা Yes, distinction paragraph 18. Now, Lordship, one other judgment on this proposition is 2000 AIR 2018, All India Report of 2000, or 2018 6 SCC, 18/6 SCC 410. Similar, on letter of allotment, subsequently the conveyance deed, the letter of allotment or whatever agreement for sale merges. Now, কোন জায়গায় দেখাবে, কোন জায়গায়?
পেনাল্টিটা ইয়ে করছে।
Paragraph 19.
Paragraph
19. This legal position is not disputed. However, in the instant case, there is no such stipulation in the agreement to sell or the sale deed. It was in the allotment letter. On the contrary, insofar as clause 7 of the sale deeds executor is concerned, the only condition imposed is that the purchaser shall use the land for the purpose of putting up a factory or factories duly permitted by the competent there for no other purpose. This makes all the difference between the two cases. Here, the undisputed fact is that the agreement for sale entered into between the parties and the respondents do not contain any clause which can be construed as condition superadded. So, well, I am same point. Now, that is why, my lord, in the final lease deed, there is specific provision for imposition of penalty fee. In one case, in the same clause, in another case, there is no provisions. That's why I am highlighting that this part. And lastly, my lord, I have to deal with my lord's judgment. Copy দাও দামোদর এটা কি দিচ্ছ তুমি এটা দোকানে একসঙ্গে দিয়ে দিচ্ছ এটা কি একটা কিছু ফ্ল্যাগ দাও ফ্ল্যাগ লাগিয়ে দাও এখানে ফ্ল্যাগ করে দাও আমাকে দুটো একসঙ্গে আছে She kindly comes to the division bench judgment straight away. আমার দাও একটা দাও আর আছে ঠিক আছে তুমি থাকো তুমি
Yes.
Paragraph 12. The other clauses, paragraph 12, internal page 12 of the division bench.
Yes, yes.
The other at the top is the construction clause, 2 Roman 3, similar to ours. Within 5 years it was there, but see that the difference is paragraph 12. The other clauses of the agreement may be of some relevance as narrated below. 2(1)b. The licensee shall be liable to pay to the authority the charges as may be imposed by the authority from time to time in respect of the said land, and in such cases where the said payments are not made within due dates, then the authority shall be at liberty to determine. This was a specific clause in that case. Now, this was the basis for the judgment, or can you see page 18 of the judgment? It's a continuation of page 15, paragraph 16. Finally, we may discuss the point raised by the appellants that the respondent authorities could neither claim penal charges as the same was not envisaged in the deed as entered into between the parties, nor could they terminate the agreement due to non-payment of such penal charges. Lordship kindly skips one page and kindly come to page 2 pages and kindly come to page 18. The middle paragraph, starting pertinent to mention. Pertinent to mention here that clause 2(1)(b) of the license deed, as mentioned above, categorically provides for imposition of charges by the authority, liability of the allottee to pay the same, and right of the authority to terminate allotment in case of failure. That is in the first part of the clause 6 in the lease deed, but not in the second part. Specifically, this provision of the deed will also operate against the appellants. And
because it falls within the purview of the terms and conditions of the contract.
yes, and
Even penal charges because contract provides penal charges.
under this was the logic. Of course, I would put my before the honorable division bench, neither before ladyship were the Supreme Court judgments placed, nor the judgment of Justice Indira Banerjee, nor the division bench judgment. Nothing was placed. But none the same, factually also this is distinguishable because of that clause 2(b)(3). That was the basis. In our case, especially, neither in the license deed provision for payment of penalty, and in the lease deed, there's expressly in one case fee penalty, in another case nothing provided. So this is my humble submission. That is all. चालावे तो मैं kindly.
Anything submitted by my learned friend. If I once again, my lord, although my learned senior friend has taken your lordship to the facts of this case, but for my convenience, my lord, may I once again invite your lordship's kind attention. So, lordship, kindly. That this a bulk plot of land measuring 30 cutters was allotted in favor of the petitioner on leasehold basis for a period of 99 years. Subject to the terms and conditions.
Sardar, you filed a written note of argument. It's not.
I have filed. But on the other day I have submitted without some other judgments I have not included. But I shall have it's all those judgments. Apart from the judgments, I have annexed with the written notes. So, if your lordship kindly takes my note. The allotment made in favor of the petitioner of the bulk land below measuring 30 cutters in at Hatishu on leasehold basis for 99 years for setting up a state-of-art newspaper printing plant on 28th August 2006, subject to the terms and conditions. Your possession was handed over to the allotee, that is a petitioner, on 8th November 2006. But you will find that page 55 is the possession certificate. Not pending, since the allotment was made on leasehold basis, pending execution of the lease deed, a license deed was executed in favor of the allotee, being the petitioner, on 21st August 2007, which is at Millard, page 57 of the writ petition. Page 55 is the possession certificate, and the license deed starts at page 57. Because some terms of the license deed are relevant to consider. If your lordship kindly comes to page 58 of the writ petition. Mirror 4 Roman 1 to pay license fee. I'm kindly skip it. Next, Roman 2 to pay all rent. To pay all rent, taxes, and other impositions in respect of the aforementioned land and structures to be erected thereon, which are or may be assessed to be payable by the owner of the or the occupier, it should be, of the occupier in respect thereof during the term of the license. Then my Lord Roman 3 says, at the own cost of the licensee, within 2 years from the date of getting license deed executed, or within such further time as the authority may, as each option allow in writing on sufficient and reasonable grounds to start construction for the purpose of setting up a state-of-art newspaper printing plant with boundary walls, sewer, drains, in accordance with plans, sanctions, specification, as shall be approved by the authorities on payment of such fees as required in accordance with the building rules of the municipal corporation, with the requirement of any land use and development control regulation of the authority, of the requirement of any other statutory rules and regulation of the local or statutory body framed for the purpose. So these two, Miller Roman 2 says that the licensee will be bound to pay all tax, rent, tax, and other impositions as may be imposed by the authority in respect of during the tenure of license. And next, Roman 3 says that it contains the stipulation that within such and such period you have to commence construction. Within 2 years or within such time as may be extended by the authority on reasonable and sufficient grounds. Well, on failure, their provision has been made in the license agreement itself, license deed itself, that on failure to comply with the terms contained in the license deed.
This is paragraph
6. You kindly come to page 60. That on failure to comply with the terms, what will be the consequence? 6.1 at page 60 of the regulation. If there be any breach of any covenant on the licensee's part herein contained, or and to be performed or observed by the licensee, it shall be lawful for the authority at any time thereafter to re-enter upon the land after determining the lease. So that right is given this. Milord, next 6.3, if you lordship kindly, Roman 3, I am skipping Milord 2, 2 is not relevant to our case. 3. Any relaxation or indulgence granted by the authority to the licensee or by the licensee to the authority shall not in any way prejudice the rights of the parties under the deed of license. Milord, the next Roman 4, Milord, I am placing for not in a, to answer. Milord, this would be relevant, Milord. My learned friend has made sufficient submission on this. Roman 4 says that upon completion of process of acquisition of land hereby licensed and transfer of the title to the said land in favor of the authority by the government of state of West Bengal, the authority shall grant and the licensee shall accept a lease of the said land described in the schedule hereunder for a period schedule hereunder written for a period of 99 years commencing from the day, month, year above, written on the same terms and conditions as may be granted, as may be agreed upon by the parties. My lord knows that even if the requiring body pays the amount, the government, being the superior landlord, has to convey the title to the in favor of the requiring. So since the land which was allotted in favor of the allotted petitioner is concerned, the process was ongoing. That is why specific term was incorporated in the license deed itself, that pending this process, completion of this process, the parties were agreed to accept this license on the terms and conditions. And it is there that upon completion of this process, my lord, the licensee shall accept a lease whenever.
Dispute.
There is no dispute. No, yes, argued on relying on this, that for want of lease deed, they could not make construction.
That has nothing to do with this.
Nothing to do.
This says that the license culminates into the lease deed upon completion of
No, there was no lease deed. He has repeatedly argued that there was why they could not make construction. Since there was no lease deed, the KMC was not granting sanction. So that was the reason for which, my lord, they could not.
Your letter to the KMC also says so.
I shall come. I shall come later on, my lord. Yes. My lord, after this, so these terms and conditions are equally binding on the parties. It goes without saying, my lord. Then your lordship kindly turns to page 66 of the writ petition.
Yes.
My lord, this lease deed was executed on 21st August 2007. Lordship kindly take note of the date. It was August 2007. And there was a condition in the license deed to start construction within 2 years or within such time as may be extended. The licensee, being the petitioner herein, my lord, did not take any step either within 2 years or even a long thereafter, my lord. They have, my lord, if you lordship kindly come to my notes at page 3. Roman 7. That I have stated in my affidavit in opposition. I have put it there now. Despite such covenant in the license deed, the licensee being the petitioner, that is the petitioner one, failed to comply with the terms by commencing construction within the stipulated time. It did not even get the land mutated in his favor within such stipulated time. The petitioner took steps for getting the building sanctioned building sanctioned by the Kolkata Municipal Corporation only in 2010. So within 2 years, the petitioner did not even mutate its name, did not even apply or did not intimate the authority of its any difficulties that for this reason we are unable. And there is a stipulation that we should start construction within such time, or failure to comply with that terms, the penal consequence is also there. Despite such stipulations, the petitioner set tight till 2010. It's an admitted fact. In 2000, much later, my lord, if you also kindly come to page 66
of the writ petition.
Of the writ petition. And this is the, for the first time, my lord, later dated 3rd May 2010. This is the first time, my lord, they prayed for extension. And up to this, and even on the date of issuing this letter, no other cause has been below stated for not commencing construction. My lord, may I read the contents? This is letter dated 3rd May 2010. This is to draw your kind attention that we would like to request you to give us an extension period till December 10, 2010 for commencing our civil work on plot number so and so. We assure your esteemed department the same would be followed strictly, failing which all necessary steps can be taken by the authority as. This is for the first time in May 2010, they prayed for extension. Because on receiving,
It will take some more time, I think.
some time is required.
So please continue on the next occasion. 1 hour.
Monday.
1 hour.
1 ঘন্টা লাগবে আপনার? 1 hour. আর 1 ঘন্টা লাগবে? So I must list the facts. And
Yes, yes,
a lot of facts are to be.
Please do. Let us continue on the next.
পরের দিন কবে করবো? রবি সোমবার টাকাটা আছে তো অবস্থা শেষ করবো। ও
5th February,
5th February.
3 p.m.
My lord, instead of 8th, can it be on 7th?
7th, 3:30.
7th, mark, as mark.
7 p.m. marked at 3:30.
7th
7th February, 3:30.
As marked.
Lordship has got some other matter fixed at 3 on 7th. Maybe Lordship
3:30 to 7 matters.
till 3.
7 matters.
Yes, they have to be obliged. 3:30 we are always sometimes mortally scared of the 3:30.
Wednesday, so.
So we expected that. It's safer that it's flush in the middle of the week. Yes.
Friday is this.